Northlands Media PR and Marketing Limited presents the Global IP Matrix Magazine Issue 19. Front cover text. Global IP Matrix Issue 19, front cover text. AI or nay, navigating legal challenges of generative AI. Non-use cancellation actions in Turkey. Turkish PTO took over the authority from the courts, so what now? Uncertainties remaining. Looking seriously at the economic value of intellectual property in Jamaica. Digital media piracy and copyright enforcement, effectiveness of copyright enforcement mechanisms in Nigeria and other African countries. Protection of computer, software programs in Sri Lanka. The future of mobility, a three-way race between hybrid, hydrogen, and electric propulsion. Headline text. Interview with the EAPO President, Dr. Grigory Ivliev, on the 30th anniversary of the Eurasian Patent Convention. Dr. Alexey Vakhnin, Russian trademark and patent attorney, Eurasian patent attorney at Vakhnin and Partners. Front cover strip advertisement. Pat World. Patent intelligence platform and research services. www.patworld.com, mail at patworld.com, telephone, +44 01633 816 601.
Page 2. Inside front cover advertisement. Salih El Amin, Intellectual Property Attorneys. We provide a full range of intellectual property services, including, but are not limited to, registration, protection, renewal, and enforcement of trademarks and brands, patents of invention, industrial/model designs, copyrights and neighboring rights, domain names, IP consultations. We are a member of INTA. IP law at salihelamin.com. www.saips.org. Telephone 971-428-688-69.
Page 3. Editor's note and Northlands Media publisher credentials. Dear readers, we are pleased to present the INTA Conference Special Edition of the Global IP Matrix magazine. The buzz surrounding this year's annual meeting in Atlanta signals a resurgence of the authentic INTA spirit, which is stronger than ever. We cannot wait to share this edition with you in person. Headlining this edition is Dr. Alexey Vakhnin, partner and managing director of Vakhnin and Partners, with an insightful interview featuring EAPO President Dr. Grigory Ivliev on the 30th anniversary of the Eurasian Patent Convention. Dr. Ivliev reflects on the historical significance of this milestone, acknowledging the visionary contributions of past leaders such as Dr. Viktor Blinnikov and Dr. Arpad Bogsh. He attributes the system's success to its business-driven nature, flexibility, and commitment to quality, while also discussing ongoing initiatives, such as the Eurasian Pharmaceutical Register and the Development Program until 2028, aimed at enhancing services and fostering international cooperation. We are excited to introduce a newcomer to the Global IP Matrix magazine, Lisa Rhooms, managing partner at Grant Henry & Rhooms, Jamaica. In her article, Lisa explores the economic value of intellectual property, IP, in Jamaica, spotlighting iconic figures like Bob Marley and Usain Bolt as examples. She delves into the challenges emerging talents face in extracting value from their IP and discusses the roles of financial institutions, venture capitalists, and government in supporting IP frameworks. Lisa emphasizes the importance of understanding IP rights, registering IP to protect it, and recognizing IP as an asset. She stresses the need for individuals and businesses to effectively exploit their IP and advocates for serious discussions and cultural shifts to realize the full economic potential of IP in Jamaica. The Women's IP World Bite-Size segment has been sponsored by barrister Bajuka Mildred Alugu and Bajuka Alib IP Sal law firm in Cameroon for this INTA special edition. In this engaging Candé, barrister Bajuka Mildred Alugu discusses her journey in intellectual property law, sharing pivotal career moments and insights into gender diversity and innovation. Reflecting on her experiences, she navigates unique challenges as a woman in a predominantly male field, emphasizing the importance of determination and skill development. Barrister Alugu's background, influenced by her father's struggles with unprotected intellectual assets, highlights the crucial intersection of legal protection and innovation. Her advocacy for inclusivity, education, and regulation underscores the need to address emerging challenges in technology and intellectual property rights. Ultimately, her perspective reinforces the vital role of diversity in promoting innovation and shaping legal strategies within the intellectual property landscape. As we conclude this preview of the Global IP Matrix's exclusive coverage for the INTA 2024 conference, we anticipate your excitement to delve deeper into the riveting and insightful content that awaits within our pages. We trust that you will find each article engaging, informative, and meticulously crafted to enhance your understanding of the evolving landscape of intellectual property. As we eagerly await the annual gathering in Atlanta, we extend our heartfelt invitation for you to join us, where we anticipate fruitful discussions and invaluable connections. Until then, we bid you farewell with anticipation for the enriching journey ahead. The Global IP Matrix magazine is published by Northons Media PR and Marketing Limited. Carlos Northon, CEO and founder. Carlos at northonsprmarketing.com. Elvin Hassan, editor. Elvin at womensipworldannual.com. Craig Barber, head of design. Craig at northonsprmarketing.com. Dhruva Dakani, head of marketing and creative design. Dhruva at northonsprmarketing.com. Page 4. Editorial Board of Directors. Malden Vukma, Vukma Attorneys, Croatia. Keisha Fleming Lake, Managing Partner at Cerveri Monsuarez, Anguilla. Laura Collada, Managing Partner, Dumont, Mexico. Max Montero, Partner, Johansson and Langlois, Chile. Ray Zhao, Senior Partner at Unitlan Attorneys at Law, China. Sarah Norka Anku, Managing Partner, S.N. Anku IP Law Firm, Ghana. Page 5. Contents page. Page 9. AI or Nay, Navigating Legal Challenges of Generative AI. Michelle S. Katz, Founding Partner at Advitum IP LLC, USA. Page 13. To oppose or not to oppose. That is the dilemma. Natalie E. Glitzenhan Augustine, Legal Practitioner at Glitz Law, St. Lucia. Page 16. Non-use cancellation actions in Turkey. Turkish PTO took over the authority from the courts, so what now? Uncertainties remaining. Azar Ferhan Sergen, Managing Partner at Sergen Law Firm, Turkey. Page 19. Distinctiveness of trademarks, the latest trends and developments in Russia. Alexey Krashuk, Partner and Head of the Trademark Department, Gorodisky and Partners, Russia. Page 23. Reinforcing online brand protection, navigating the European NIS2 directive. Natalie Dreyfus, Trademark Attorney and Certified Expert at the French Supreme Court, and Milena Dreyfus, IP/IT Lawyer at Dreyfus, Paris, France. Page 27. Looking seriously at the economic value of intellectual property in Jamaica. Lisa Rhooms, Managing Partner at Grant Henry & Rhooms, Jamaica. Page 30. How my recent partnership with a global law practice positions me to provide exceptional services related to intellectual property law in the Caribbean region. Keisha Fleming Lake, Managing Partner at Cerveri Monsuarez, Anguilla. Page 33. Interview with the EAPO President, Dr. Grigory Ivliev, on the 30th anniversary of the Eurasian Patent Convention. Dr. Alexey Vakhnin, Russian trademark and patent attorney. Eurasian patent attorney at Vakhnina and Partners, Russia. Page 38. Protection of computer, software programs in Sri Lanka. Anomi Wanigasekara, Partner and Sabira Sharif, Senior Associate at Julius & Creasy, Sri Lanka. Page 41. The Future of Mobility, a three-way race between hybrid, hydrogen, and electric propulsion. Dean Parry, Technical Director, and Claire Gibson, Senior Patent Analyst at Patworld, UK. Page 46. The Eurasian Pharmaceutical Register, an instrument for pharmaceutical companies. Aurelia Sieben, Deputy Director of the Examination Department and Head of the Chemistry and Medicines Division at the Eurasian Patent Office, Russia. Page 49. Digital media piracy and copyright enforcement, effectiveness of copyright enforcement mechanisms in Nigeria and other African countries. Alexey Vakhnin, Partner at Benchmark and INTA, Nigeria. Page 53. Navigating Intellectual Horizons, a conversation with Barrister Bijuka Mildred Alugu. Barrister Bijuka Mildred Alugu, Managing Partner at Bijuka and Partners Law Office, Cameroon. Page 56. Navigating the intersection of creativity and legal strategy. A conversation with Laura Castillo from Inventiva Espacio Legal. Laura Castillo, Partner at Inventiva Espacio Legal in the Dominican Republic. Page 60. Expanding in Latin America and the Caribbean, an update from INTA. Carolina Belmar, Chief at INTA, LATAM and the Caribbean Office. IP, Data and Cybersecurity Lawyer, Chile. Page 62. Shine bright in Antwerp at the ECTA 42nd Annual Conference. Carina Gomez, ECTA First Vice President and Partner at Wigan LLP, Belgium. Page 65. A busy year for Marques. Anthony Douglas, Legal Director IP, Data Protection, Marketing and Digital Strategy at Specsavers and Chair of the Marques Council. Page 68. Exploring the Frontiers of Intellectual Property, a sneak peek into the 2024 AIPPI World Congress in Hangzhou, AIPPI team members. Page 6. Contributors. Contributors page. Michelle S. Katz. Founding Partner at Advitum IP LLC, USA. Natalie E. Glitzenhern Augustine. Legal Practitioner at Glitz Law, St. Lucia. Azar Ferhan Sergen. Managing Partner at Sergen Law Firm, Turkey. Alexey Krashuk. Partner and Head of the Trademark Department, Gorodisky and Partners, Russia. Natalie Dreyfus. Trademark Attorney and Certified Expert at the French Supreme Court, Dreyfus, Paris, France. Lisa Rhooms. Managing Partner at Grant Henry and Rhooms, Jamaica. Keisha Fleming Lake. Managing Partner at Cerveri Monsuarez, Anguilla. Dr. Alexey Vakhnin. Trademark and Patent Attorney, Eurasian Patent Attorney at Vakhnina and Partners, Russia. Anomi Wanigasekara. Partner at Julius and Creasy, Sri Lanka. Milena Dreyfus. IP/IT Lawyer at Dreyfus, Paris, France. Dean Parry. Technical Director Claire Gibson, Senior Patent Analyst at Patworld, UK. Sabira Sharif. Senior Associate at Julius and Creasy, Sri Lanka. Aurelia Sieben. Deputy Director of the Examination Department and Head of the Chemistry and Medicines Division at the Eurasian Patent Office, Russia. Alexey Vakhnin. Partner at Benchmark and INTA, Nigeria. Claire Gibson. Senior Patent Analyst at Patworld, UK. Barrister Bijuka Mildred Alugu. Managing Partner at Bijuka and Partners Law Office, Cameroon. Laura Castillo. Partner at Inventiva Espacio Legal in the Dominican Republic. Carolina Belmar. Chief at INTA, LATAM and the Caribbean Office. IP, Data and Cybersecurity Lawyer, Chile. Carina Gomez. ECTA First Vice President and Partner at Wigan LLP, Belgium. Anthony Douglas. Legal Director IP, Data Protection, Marketing and Digital Strategy at Specsavers and Chair of the Marques Council.
Page 7. Advertisements. Advert 1. Mark Inventa Intellectual Property Services. Your intellectual property agent in Eastern Europe and Asia. European patent and trademark attorneys. Trademarks, patents, assignment, industrial designs, opinions, oppositions, patent annuities, renewal designs, renewal trademarks. Contact details. Mark Inventa Company Limited. Intellectual Property Services. Glinska Ulica 14. 1000 Ljubljana. Slovenia. Phone +386 1 426 650 3. Fax, +386 1251 050 Phone, +386 1540 4331. Fax, +386 1524 3118. Email, office@mark-inventa.si. Website, www.mark-inventa.com. Advert 2. Deep and Far Text Advert. Deep and Far attorneys at law since 1992. IP right prosecution and litigation, corporate legal and consulting, IP value-added services. Focus is patents, trademarks, copyrights, trade secrets, unfair competition, licensing, counseling, litigation, transaction. Territories: Taiwan, mainland China, Hong Kong, and Macau. Fields: mechanics, chemistry, pharmacy, biology, electronics, optics, telecommunications, and computer sciences. Address: 13th floor, 27, Sec. 3, Chung San N Road, Taipei, Taiwan. Telephone: 886-2258-56688. Email at deepnfar.com.tw. Website: www.deepnfar.com.tw. Advert 3. Now it's your turn to control Bangladesh. Supreme IP Law Firm, Bangladesh. Telephone: 88-0161-333-6333. info@supremeip.com. www.supremeip.com. Advert 4. H.K. Acharya and Company, India. Advocates, patent and trademark attorneys. Perfection is our passion. Telephone: 9179-2642-5258. www.hkindia.com.
Page 8. Advertisements. Advert 1. Singh and Singh. Singh and Singh Law Firm LLP is an Indian law firm with years of experience in providing services inter alia in the field of intellectual property law, media and telecommunications laws, arbitration, competition law, law of taxation, drugs regulatory laws. With a highly qualified and experienced team of legal professionals, the firm is able to identify the core of a client's issues to provide suitable solutions. Singh and Singh Law Firm LLP. C139, Defence Colony, New Delhi, 110024, India, T, +91 11 4982 6000 6090. Email at singhandsingh.com. Advert 2. Berry & Berry, European and Polish patent and trademark attorneys. Patents. Post-grant. Trademarks. Designs. Email, berry@bnb-ip.eu. www.bnb.ip.eu.
Page 9. Article. AI or Nay, Navigating Legal Challenges of Generative AI. Written by Michelle S. Katz, founding partner at Advitum IP LLC, USA. Artificial intelligence has crept into practically every facet of our lives. For attorneys and law students alike, generative AI has become a tool for efficiency and accuracy when producing briefs or memoranda. It ultimately cuts monetary costs to clients, but at what ethical cost? Consider the situation where a law student submits a law review article written by AI or an attorney files a brief containing fabricated case law generated by AI. While these AI-generated documents may be indistinguishable from those written by humans, they raise important ethical questions about authenticity, integrity, and professional responsibility. In recent months, LexisNexis released their own version of AI for legal research, the AI Assistant. This tool can be used to ask questions, summarize cases, and draft documents. This tool may have been put in place as a response to increased uses of ChatGPT in legal settings, as a way to deter students and practitioners from using non-legal tailored AI tools. The AI assistant, however, may have some bugs of its own, leaving researchers to spend more time fact-checking the supposedly helpful tool or going back to the drawing board and performing their own legal research. Further, the reliance on AI for legal research and document drafting poses risks to client confidentiality. Inputting sensitive client information into AI platforms could potentially compromise client data privacy, leading to breaches of confidentiality and ethical violations. Other information breaches may come from the clients themselves. If they want to patent an invention, they may simply ask an AI tool, "Is X patentable?" or "Is X already patented?" A law student could enter the same thing into Lexis AI. Unbeknownst to them, they may have just made a public disclosure of the client's invention. In some time-sensitive matters, practitioners may rely too heavily on AI without checking the accuracy of the information it delivers. In June 2023, U.S. District Judge P. Kevin Castell in Manhattan imposed sanctions on 2 New York lawyers who submitted a legal brief that included 6 fictitious case citations generated by ChatGPT. The judge found the lawyers acted in bad faith and made acts of conscious avoidance and false and misleading statements to the court and, accordingly, had to pay a $5,000 fine. If practitioners are not careful, these sanctions may become the norm. In response to these concerns, there is a growing call for regulatory standards and screening protocols to detect and address the use of AI in legal practice. Organizations like the American Bar Association, ABA, may need to introduce ethical guidelines into the model rules of professional conduct specifically addressing the use of AI technology. These guidelines could include requirements for attorneys to disclose the use of AI-generated content in legal documents, as well as protocols for safeguarding client confidentiality when utilizing AI platforms for research and document drafting. Additionally, there may be a need for ongoing CLE programs to provide education and training to ensure that legal professionals understand the ethical implications of AI use and how to navigate it responsibly. Generative AI can be a valuable tool for legal professionals, aiding in tasks such as drafting, summarizing, and comparing categories of documents. AI has its limits, however, and it may be the case that it is only reliable and is only used ethically when used for very general tasks such as drafting generic client communication, devoid of any personal and confidential information, structuring arguments, or for simple research purposes. Regardless, practitioners must exercise caution and scrutinize the work produced by these AI tools, ensuring that it is checked and verified. They must also exercise their own independent judgment on complex legal matters. AI platforms such as ChatGPT and Lexis AI Assistant were introduced and have been used to increase efficiency and cut costs. As the legal profession continues to adapt to the digital age, thoughtful consideration of the ethical implications of AI use will be paramount in ensuring that justice is served ethically and responsibly. Relying on these tools without reviewing their output, knowing they could generate false information, though it may sound accurate, is ultimately doing a disservice to the legal profession and the clients we serve. Acknowledgement is extended to Carlin Miller, law clerk, for her valuable assistance in conducting research for this article.
Page 11. Advertisement. Centric IP. Empowering creativity, enforcing IP rights. Your IP partner for protection, through management to enforcement. Analyzing, protecting, and managing your IP rights in India subcontinent. Telephone 91-892-967-5463. Email info@centric.com. www.dtcertic.com.
Page 12. Advertisement. ASIPI. La Antigua, Guatemala 2024. Registration open. www.asipi.org/Guatemala 2024. June 2nd to 4th, Hotel Casa Santo Domingo. Coexistence or collision. Challenges and opportunities in the era of artificial intelligence. ASIPI.
Page 13. Article. To oppose or not to oppose. That is the dilemma. Written by Natalie E. Glitzenhan-Augustine, legal practitioner at Glitz Law, St. Lucia. As a lawyer and thus inherently a litigator, when a client speaks to me of opposition, I am apparently supposed to get excited, rub my hands in glee, and get to drafting whilst already practicing my closing submissions. Right. Well, maybe not always. You see, just because your diligent searches in the pursuit of protecting your client's existing mark may have led you to something similar in the process of being registered in your jurisdiction, This does not automatically mean that proceedings need to be instituted to set off what is usually a long drawn-out battle of your mark versus my mark. As distressing as it may be to litigators, the attempted registration of a similar trademark to that of your client may not need to be opposed in certain circumstances, especially when a workable agreement can be arranged between the parties. There are occasions when a non-litigious solution can be arrived at due to the use of or there being notable distinctions in the marks, such as coexistence agreements. These are of use should a situation arise in which the owner of an existing trademark and the applicant of a similar trademark agree to coexist peacefully and not challenge each other's rights in the market. Due to operating in different service areas or entirely different products, they may agree and enter into a coexistence agreement, setting boundaries as to each other's use of the similar marks, such restrictions addressing perhaps place of display, use of taglines, prohibited markets, etc. In such cases, once an agreement is arrived at and adequately drafted, drawn up and executed, it is often advisable to file the same with the registrar, ensuring that the registration can proceed without any delays due to concerns they may raise. Different goods or services. Another situation when a trademark opposition action may not be necessary is if a similar trademark is used for goods or services that are sufficiently distinct from those associated with the existing trademark of your client that you are trying to protect. It may be the case that the trademarks will be registered within totally different classes, with the result that their individual user by the respective owners is unlikely to cause confusion or conflict due to being utilized in different industries or by clients offering different products or services. In such cases, the registration by the second owner in time is justifiable, and an opposition action should not be pursued. Prior consent or licensing. One way of avoiding the dilemma of to oppose or not to oppose is if the owner or user of an existing trademark provides explicit consent for the registration of a similar trademark by another party. This, like with a coexistence agreement, eliminates the need for opposition to the intended registration, even if the similar mark has, in fact, only ever been used by one party, and it is the second party now seeking to effect first registration. This type of grant of use can also occur expressly through a licensing agreement, where one party grants written permission to the other to use their pre-existing trademark. Acquired distinctiveness. In this circumstance, opposition might initially be threatened, but with some discussion between the parties, it might be possible for them to reach an understanding. This possibility can arise when the party seeking to register their mark can demonstrate to the owner of the prior registered mark that their similar trademark has acquired distinctiveness or secondary meaning in the marketplace and poses no threat, or is unlikely to give rise to confusion between the two marks by the public at large. If persuasively raised in the discussions between the parties, this reasoning should not give rise to an opposition application being filed. One such line of argument would be to submit, necessarily along with proof, that consumers have come to identify the trademark sought to be registered with a particular source or type of goods or services, even though the mark itself may not be inherently distinctive and speak to the same. Locally, here in St. Lucia, I can imagine a situation where the government may seek to register a mark for the STEP, short-term employment program, and the international organization headquartered in England, whose focus is on trust and estate planning, gets wind of this. Would it serve STEP UK any purpose to oppose the St. Lucia government's intended registration when STEP clearly has a secondary meaning in St. Lucia? Generic or descriptive use. One last situation where there will not be a need for opposition is when a particular trademark presented for registration is purely descriptive or generic in nature and may not even be eligible for registration in the first place. If such a similar trademark falls under either of these categories, there may be no need for opposition as it would or should not meet the requirements for trademark protection. Naturally, every country's prevailing laws might differ regarding what is deemed generic or descriptive, and the subjectiveness of the arbitrating registrar must also be considered. Still, overall, the rulings in this regard have been reliably similar across the jurisdictional board. Having now curtailed your litigious itch and kept you from running straight to your registry or court, it is important to note that the specific requirements and exceptions for opposition may, and I am sure, vary across jurisdictions. If the situation presents itself, we at Glitzlaw would be happy to consult with you to determine whether there is a need to oppose the registration of a similar trademark registration in St. Lucia. If you happen to be at INTA in Atlanta, speak to us at booth number 555 to discuss this further.
Page 15. Advertisement. Glitz Law. Attorneys at Law. Full-service civil law firm. St. Lucia's IP experts. Intellectual property services. Trademarks, copyright, PCT national applications, patents, oppositions, searches, assignments, renewals. www.stluciafinance.com. Natalie.augustine@glitz-law.com. Suite number 1, first floor, Bourbon House, Bourbon Street, P.O. Box 1, 695 Castries LC 04101, St. Lucia.
Page 16. Article. Non-use cancellation actions in Turkey. Turkish PTO took over the authority from the courts, so what now? Uncertainties remaining. Written by Azar Ferhan Sergen, managing partner at Sergen Law Firm, Turkey. Trademark use requirements have existed in Turkey for a long time, as in many other jurisdictions. Trademarks must be used within 5 years after registration, otherwise, they can be subject to cancellation actions by third parties. According to old legislation enacted in 1995, IP courts were authorized to handle such cancellation lawsuits due to the non-use of trademarks. In 2017, a new IP code entered into force, which handed over this authority from courts to the Turkish Patent and Trademark Office. During the lawmaking process, the PTO representatives justifiably declared at the Turkish Parliament Commission's meetings that the office was not ready to handle such a task and would need some preparation time. Accordingly, the entry into force of the relevant article regulating the office's authority to handle non-use cancellation actions was postponed for 7 years through the addition of a provisional article at the end of the new IP code. At that time, it was understandable that the office should be allowed to make necessary arrangements and appoint and train sufficient staff and resources to handle the task, though the question was whether 7 years of time was necessary for that. Whilst we are not aware if the office has really worked on establishing a new structure for handling these actions within this period of 7 years, it has just come to the attention of the stakeholders at the end of 2023 that a draft regulation has been prepared which the stakeholders have commented on. It officially came into force on the 10th of January 2024, and the exclusive authority for handling non-use cancellation actions was handed over to the office for the courts. The uncertainties also became more crucial after this date because those concerned were not able to file a lawsuit with the IP courts for these actions for which there was at least an established and foreseen procedural law. On the other hand, the office was not properly providing a path to file and pursue a non-use cancellation action as well. In the present day, it is still more or less the same because the office publishes no specific regulation or guideline on how these cancellation actions will be handled. The procedure, deadlines, notifications, and the decision-making process are all still unknown. The office has only started to accept requests for cancellation of a trademark grounding on non-use, named these requests filings as pre-applications, apparently for not being able to accept and proceed with real applications without at least a regulation to lead the way for examiners. It is now expected from the office as soon as possible to publish a new regulation, a new guideline as well as necessary forms and papers for users, the official fees for these applications, to send notifications to all pre-applicants requesting to fulfill potential deficiencies and deposit official fees for concluding their applications and to provide a transparent and a foreseeable procedural way to all the stakeholders. Why is this so important? If we put aside some complex cases, including disputes on whether trademark use is genuine, continuous, serious enough to make a commercial impact, and can be considered a use defined by the law, the vast majority of these non-use cancellation actions are rather simple, in which there is no use at all. It does not matter whether it is held by the courts or the office. The burden of proof is on the defendant, who is the registrant of the disputed trademark. The problem was always the length of the proceedings, and thus, the expectation was and is still high that the office would be able to handle these actions swiftly. During the litigation process, even if the defendants were not able to submit any evidence of use, these cases had the potential to last for at least 5 years, including the first instance court, second instance regional court, and Supreme Court stages, where decisions are appealed by defendants. In the meantime, defendants sometimes filed repeat marks with the office. At the same time, the non-use attack was ongoing in the litigation process against their prior trademarks. The office examiners did not consider the oppositions filed by the plaintiffs grounding on the bad faith of the applicant-defendant, deciding the registration of repeat marks grounding on the reason that the prior marks cancellation is still in the litigation process and has not become final. Then, the plaintiffs are forced to file further lawsuits against the same defendant for invalidation of repeat marks, and the situation becomes chaotic with never-ending court cases. Although the prior trademark can be cancelled, and further repeat marks can be invalidated after 5 to 10 years of the litigation process, including several court actions, it is usually worthless on the commercial side where the speed of the legal system cannot catch up. In other words, justice delayed is justice denied. That's why the office handling these non-use cancellation actions within a short period of time, such as less than 6 months in an ideal world, would be exciting to have after all the years of struggling with the foregoing issues churning around the same problem of long-lasting court actions. There is no doubt about the delay in properly implementing the procedures for these non-use cancellation actions, but we should be hopeful that the office will look into this matter more closely soon, solve the existing problems, and provide a sustainable system as soon as possible.
Page 18. Advertisement. Global Intellectual Property Convention, Istanbul 2024. Learn and collaborate. 16th edition, 6th to the 7th of June 2024. Cultivate deep connections, shape the future of IP, and immerse yourself in the vibrant tapestry of Istanbul. www.globalipconvention.com.
Page 19. Article. Distinctiveness of Trademarks, the Latest Trends and Developments in Russia. Written by Alexey Vakhnin, Partner and Head of the Trademark Department, Gorodisky and Partners, Russia. In Russia, as in other jurisdictions, distinctiveness is a key registrability criterion that a trademark must meet in order to get registered. Russian law states that a designation will be refused protection if it lacks distinctive character. As a general rule, a designation should be considered as being devoid of distinctiveness if it represents itself as a simple letter, simple non-stylized combinations of letters that are not perceived as words, simple geometrical figures or lines or combinations thereof that do not form a composition having a completely different level of perception as compared with that of the figures or lines if viewed separately. Also, non-protected are those designations that bear descriptive character, especially descriptive signs that denote nature, properties, purpose, and other characteristics of goods. As regards non-traditional marks such as shape or design marks, Russian law makes it clear that a designation featuring the shape or design of a product or its packaging shall not be allowed to proceed to grant if the shape is a functional one, in particular, if it is exclusively or predominantly due to the properties and purpose of goods. Russian law further asserts that realistic depictions of products are deemed non-distinctive if these are applied for registration with respect to those products. The law, however, provides for some exceptions from those strict requirements. In particular, it states that inherently non-distinctive signs can still be granted protection if they have acquired necessary distinctiveness through intensive use on the Russian market. The acquired distinctiveness is to be proved and confirmed with documents to enable the brand owner to rely on the respective claims when arguing the protectability of its mark for registration purposes. Under official regulations adopted in Russia, the documents that could be filed in support of the acquired distinctiveness should disclose factual information as to the scale and length of use of the mark that is sought to be protected, in particular information as to the territory of sale of the branded goods, turnover and sales figures attributed to the applied goods, brand awareness information including survey results, media publication and promotional materials and others. The documents submitted by the brand owner are to be considered in the aggregate and, when examined entirely, should give an idea as to the scale and intensiveness of use of the mark as applied, especially on the Russian market before the priority date. The documents are to be taken into account if they clearly demonstrate that the mark is perceived by consumers as a means of individualization of a particular trader. The current practice in Russia suggests that proving distinctiveness is a complex task. In some cases, even a stainless global reputation, goodwill, and awareness associated with the mark alone may not suffice to persuade authorities that the mark has gained secondary meaning in the local market. One of the recent trademark cases perfectly illustrates the complexity of the task and shows the current trends crystallized in the Russian practice. The case concerns a well-known design of a BIC pen that was applied for registration in Russia as a 3D mark featuring the pen's shape. The application to register the mark was filed in respect of goods in Class 16, namely pens of different types, especially ball pens, in the name of the French stationery maker Bic SA. Upon examination, the application was refused protection due to non-distinctiveness. In particular, the examining attorney concluded that the mark was a realistic depiction of a product and was intended to be used on such a product. Moreover, it was stated that the mark featured a shape of the product that was allegedly quite traditional for the market due to its functional nature. The applicant appealed against the refusal decision based on the acquired distinctiveness claim. The applicant, in particular, referred to the history of the brand owner and the brand itself, drawing attention to the fact that the company was founded in 1945 and that in 1950, a ball pen was invented and introduced on the global market under the brand name Bic Crystal. Sometime later, the pen became increasingly popular worldwide, with annual sales reaching approximately 500 million items and holding roughly 60% share of the pen market. By 2006, the Bic Crystal pen was declared the top-selling pen in history, with the total number of sold items being 100 billion. The appeal further stated that the unique Bic Crystal design of the pen was repeatedly recognized by the NY Museum of Modern Art, where one of the ball pens is constantly displayed as an exhibit. As regards the local market, it was mentioned in the appeal that the sale of the Bic Crystal branded pens commenced as early as the 1960s, and over recent years, the pen was intensively promoted in Russia through various trade channels, including the largest retail chains, such as Metro, Cash and Carry, Auchan, Oki hypermarkets, as well as different marketplaces operating in Russia. The applicant further claimed that it was sponsoring promotional events in Russia and that the applied designation became quite famous in Russia because of the very active trading activities. In support of the claims, the applicant produced an affidavit, various promotional materials, shipment documents, and opinion poll results demonstrating high awareness and recognition among consumers in Russia. Despite the large amount of evidence submitted, the appeal authorities did not find it persuasive enough to overturn the refusal. First of all, the board insisted that the shape of the pen was quite traditional for the market as it contained the main constructive elements specific to such kind of goods, faceted body, cap and protective cover, that looked quite similar to those used by other traders. In support of its arguments, the board referred to the existing pen designs of other traders. This fact made the board believe that the proposed shape was more or less functional and inherently non-distinctive due to the lack of original decorative elements that could make it sufficiently distinguishable from third parties' pen shapes represented on the market. On the other hand, the evidence of acquired distinctiveness submitted by the applicant was disregarded by the board as it related to the mark that was essentially different from the applied one in that it was used in combination with additional distinctive elements such as the words Bic Crystal or BIC logo that was not part of the applied designation. Further, according to the board, some of the sales figures referred to in the appeal were not confirmed by documents, e.g., sale and purchase contracts, advertising agreements, etc., whereas some of the documents mentioned third-party companies as a consignor, although no documents to confirm the relationship between the applicant and the third parties were produced. Finally, the board made it clear that, given the lack of factual proof of the use of the mark as applied, the poll results, even though favorable overall, could not change the board's opinion that the mark was not entitled to protection as being devoid of distinctiveness. This case allows us to make the following conclusions. The registrability requirements are the same for both traditional and non-traditional marks, such as shape marks. The evidence of acquired distinctiveness should relate to the mark as applied without additional elements. Before the priority date, it must demonstrate intensive and long-standing use in the local market. If the mark is promoted on the local market by related, affiliated companies or third-party contractors, then the respective evidence attesting to the relationship between all the parties involved in the supply chain should be submitted. The evidence submitted is considered in the aggregate, and different types of evidence used in defense should correspond. As such, the poll results, even though favorable, may not prove sufficient to argue acquired distinctiveness if there is a shortage of factual use evidence. Another interesting case from the recent practice worth highlighting is the one related to a combined mark featuring some non-distinctive elements, such as the state flag and descriptive text. The mark was applied for registration with respect to cheese in Class 29 in the name of Savencia S.A. France, and, as a result of the examination, was refused protection due to lack of distinctiveness. In particular, the PTO found the mark to be non-distinctive based on the fact that the non-protected elements of the mark, such as descriptive signs denoting specific types and properties of goods, allegedly dominated the mark, making the mark non-distinctive as a whole. Also, the examining attorney insisted that the applicant should submit permission from a competent body to use a depiction imitating the state French flag as part of the mark. In an attempt to dispute the refusal decision, the applicant agreed with the registry's position in that certain elements of the mark, especially the words elements French soft cheese in Russian, incredible cream taste in Russian, and the word supreme on its own, might in fact be non-distinctive. In the meantime, the applicant was of the opinion that the mark, if viewed as a whole, was quite distinctive because of the unique composition and coloristic solution, as well as stylization, utilized in respect of an eye-catching word element supreme. The applicant further argued that it was in a position to delete the graphic element that imitated the state symbol of France and requested the respective amendments to the mark. However, the appeal was unsuccessful, and the registry left the refusal in force. The refusal decision could still be subject to a further appeal with the IP court, and the applicant made a further attempt to have the refusal decision overturned to pave the way for the mark to proceed to grant. In the first instance, the court satisfied the appeal and obliged the PTO to have the mark registered. In finding the mark registrable as a whole, the court referred to the fact that the applied designation was a label that featured original graphic composition due to the oval-shaped form, unique combination of elements, usage of distinctive stylization and coloristic solutions that altogether contributed to the distinctiveness of the mark. The court also considered that the applicant owned exclusive rights in and to the word mark supreme in Russian transliteration. That said, the mark was found distinctive as a whole, and no disclaimer requirement was issued. However, that was not a happy end in the proceedings, and the case went further to the Cassation Court, where the favorable decision was totally annulled and returned to the lower court instance for reconsideration. The annulment resolution was motivated by the fact that the first instance court did not pay due attention to the possible perception of the mark when used on the applied goods by the respective consumers, nor did it analyze the elements incorporated by the label to establish which one of them was distinctive or descriptive and which elements were dominating. Also, the Cassation Court insisted that it was not clear whether the non-distinctive elements, when viewed as a whole, formed a graphically unique composition with a completely different perception level. This case shows that label marks may face serious non-distinctiveness objections as the non-protected elements, such as descriptive signs, that are quite common and specific for the labels may be deemed dominating. If so, the main issue is to understand whether such elements, although descriptive in their nature, when put together, form a composition that is perceived differently by consumers as compared with those elements if viewed individually. Overall, the distinctiveness issue is one of the key criteria for establishing the registrability. The distinctiveness may be inherent or acquired. The inherent one may not be obvious in many cases, and additional analysis may be necessary. The acquired distinctiveness requires persuasive proof of intensive use, which may be a difficult task. Nevertheless, it appears that the basic principles and legal approaches that have been worked out in practice have remained unchanged for a long time, which makes the outcome in such cases quite predictable in accordance with the legal expectation doctrine. Page 23. Article: Reinforcing Online Brand Protection, Navigating the European NIS2 Directive. Written by Nathalie Dreyfus, trademark attorney and certified expert at the French Supreme Court, and Milena Dreyfus, IP/IT lawyer at Dreyfus, Paris, France. In the ever-evolving landscape of the Internet, the protection of trademarks online has become a paramount concern for businesses and legal professionals alike. The recent developments in the European Union's regulatory framework, particularly the Directive (EU) 2022/2555 of December 14, 2022, on measures for a high common level of cybersecurity across the Union, NIS2 Directive, present both challenges and opportunities for online brand enforcement. This article aims to provide a comprehensive overview of these developments, elucidating the implications for trademark owners and proposing strategic approaches for navigating the new regulatory environment. The rising tide of phishing and its implications. The surge in phishing attacks since May 2020 has been alarming, with a notable increase in the sophistication and volume of these attacks. The INTA Consulting Group's Phishing Landscape Report, dated August 9, 20,231 highlights a tripling of such incidents, emphasizing the heightened risk environment for trademark owners online. The use of generic top-level domains, GTLDs, and country code top-level domains, CCTLDs, in phishing exploits has underscored the urgent need for enhanced vigilance and proactive trademark protection measures. 34% of GTLD domain names reported for phishing are used within 48 hours of their appearance. Most importantly, 85% of domain names associated with a phishing attack were reported in the first year of registration, increasing the need for proactive and constant online monitoring. NIS2 Directive, an important evolution in terms of cybersecurity obligations. The NIS2 Directive was published on December 27, 2022, and entered into force on January 6, 2023. All European Union member states have until October 17, 2024, to transpose it. It provides measures aimed at ensuring a common high level of cybersecurity throughout the European Union and, hence, marks a significant expansion in the European Union's cybersecurity regulatory framework. A broad scope of application. It is interesting to note that the former definition of essential service operator, ESO, is being replaced by the notions of essential entities, which provide critical services for society, and important entities, which are based on the entity's number of employees and sales. Most notably, the NIS2 Directive includes all DNS players, including registries, registrars, and domain name resellers, whatever their size. The NIS2 Directive encompasses various sectors, including digital services such as social networking and digital service providers, providers of online marketplaces, search engines, and social networks. Among the sectors concerned, digital services providers play a vital role since they include three types of digital services too. Online marketplaces that enable consumers or professionals to conclude online sales or service contracts with professionals, either on the website of the online marketplace or on the website of a professional who uses the IT services provided by the online marketplace. Providers of online search engines and social networks. Consequently, all activities related to online sales may fall under the scope of the NIS2 Directive. Article 26 of the NIS2 Directive highlights a significant advancement. The directive covers not only all companies offering services or activities in the European Union but also companies based in the European Union or those providing services to European citizens, including those based abroad, if they operate in the targeted sectors. Clear objectives. The NIS2 Directive aims to increase the resilience and security of networks and information systems, extend European regulations to improve cybersecurity within the European Union, introduction of stricter security requirements, as well as incident reporting obligations, correcting misinterpretations of the RGPD by offering notably a revised WHOIS policy, Article 28. Imposing stricter safety requirements and enhanced reporting obligations on entities. The directive's expanded scope and the emphasis on accountability underscore the European Union's commitment to bolstering the cyber resilience of its digital single market. Stricter safety requirements, Recital 137 and Article 21. Pursuant to Recital 137, the NIS2 Directive should aim to ensure a high level of responsibility for the cybersecurity risk management measures and reporting obligations at the level of the essential and important entities. Therefore, the management bodies of the essential and important entities should approve the cybersecurity risk management measures and oversee their implementation. Essential and important entities are indeed required to take appropriate and proportionate technical, operational and organizational measures to manage security risks and to eliminate or reduce the impact of incidents on recipients of their services and on other services. 3. Consequently, responsibility is transferred to the company's top management. In line with this disposition, the main objective today of online brand enforcement is to reduce the risk caused by cybersquatting, notably phishing. Technical, organizational and operational measures include risk and information systems analysis, Network security. Measures to guarantee business continuity in the event of incidents. Training in cyber risks and best practices. Requirement for an incident management team. Obligation to declare a security incident to ANSSI, 24H, present an impact assessment, 72H, and provide a full report, 1 month. Securing the supply chain, including the security of relations between each entity and its suppliers or direct service providers. The consequences of online brand enforcement are significant. Preventive action against domain names identified as dangerous becomes necessary, and the legal department will participate in the fight against cyber incidents and coordinate incident reporting. Focus on the duty to inform imposed by Article 23. Article 23 of the NIS2 Directive provides that essential and important entities shall notify, without undue delay, its CSIRT or, where applicable, its competent authority, of any incident that has a significant impact on the provision of their services. Concretely, essential and important entities must comply with a 3-step process. Address an initial notification to the relevant authority, ANSSI in France or CSIRT, within 24 hours of becoming aware of the significant incident. Address another notification to the same relevant authority detailing the impact of the incident within 72 hours of becoming aware of the significant incident. A final report within 1 month after the submission of the second notification must also be sent, including a detailed description of the incident, notably its severity and impact, the type of threat or root cause that is likely to have triggered the incident, applied and ongoing mitigation measures, and, where applicable, the cross-border impact of the incident. Online frauds based on cybersquatting domain names are concerned by this duty to inform. Indeed, the incident will be considered significant if it has caused or is capable of causing severe operational disruption of the services or financial loss for the entity concerned. Such incidents relate, for instance, to phishing aimed at company employees or partners, fraud on the president, or introduction into an email chain using typersquatted names. The incident will also be qualified as significant under Article 23, it has affected or is capable of affecting other natural or legal persons by causing considerable material or non-material damage. 4. This category includes notable loss of value such as market capitalization, damage to company image reputation, marketing of products that do not comply with regulations or are dangerous, or cryptocurrency scams, which often involve huge amounts. Focus on the obligations imposed by Article 28 on top-level domain name registries and entities providing domain name registration services. The obligations imposed by Article 28 of the NIS2 Directive on top-level domain name registries and entities providing domain name registration services could be a game-changer for trademark owners and their legal representatives, by implementing verification policies and procedures to ensure that database information is accurate and complete. The objective behind Article 28 is clear: make public, without undue delay after the registration of a domain name registration data that are not personal data, notably the name of a company, its registration number, and email address. Recital 112 of the NIS2 Directive even provides that the access procedure could include the use of an interface, portal, or other technical tool to provide an efficient system for requesting and accessing registration data. Under Article 28 of the NIS2 Directive, database of domain name registration data must contain the necessary information to identify and contact the holders of the domain names and the points of contact administering the domain names under the TLDs. Such information shall include the domain name, registration date, the owner's name, email address, and telephone number enabling to contact him, the email address and telephone number for contacting the contact point that manages the domain name if these details differ from those of the registrant. Such proportionate procedures for verifying domain name registration data were eagerly awaited by trademark owners and their legal representatives. Additionally, top-level domain name registries and entities providing domain name registration services must provide access to specific domain name registration data upon legitimate and duly motivated requests, which could be based on rights other than trademark rights, from legitimate access requesters, and respond without undue delay and, in any event, within 72 hours of receipt of any request for access. The impact Article 28 of the NIS2 directive might have on defense strategies is non-negligible. It allows additional and more effective means to act against fraudsters by applying to the entire chain of DNS players, imposing on them the obligation to verify registrants' identities and facilitate access to verified who-is data within a reasonable timeframe, 72 hours. Additionally, the consequences for online brand enforcement could be tremendous. By imposing an obligation to disclose the identity of fraudsters, Article 28 of the NIS2 directive holds a deterrent effect. Will it be the end of anonymization? And allows trademark owners to initiate direct actions against actors who could not be immediately concerned since they were not identified. The timely availability and accessibility of domain name registration data to legitimate registrants is essential to prevent and combat DNS abuse, as well as to prevent, detect, and respond to incidents. Ultimately, the European Union's latest regulatory developments in cybersecurity present a new and complex landscape for online brand enforcement. While the challenges are significant, these developments also offer an opportunity for trademark owners to strengthen their defenses against online fraud and abuse. By adopting a comprehensive and proactive approach to compliance, monitoring, and using innovative tools, entities can navigate these challenges effectively, safeguarding their online presence and, ultimately, protecting the company, its directors, and clients in the digital age.
Page 26. Advertisement. 2024 AIPLA Annual Meeting. Join over 100 professionals from around the world for 3 days of networking and education. Registration opens on July 31st. October 24th to 26th, 2024. Gaylord National and Resort and Conference Center, 201 Waterfront Street, National Harbor, MD, USA.
Page 27. Article. Looking seriously at the economic value of intellectual property in Jamaica. Written by Lisa Rhooms, Managing Partner at Grant Henry & Rhooms, Jamaica. Jamaica has arguably produced some of the world's biggest, most recognizable, and most valuable brands. One such brand is Bob Marley, a brand that transcends the music realm and has tremendous intellectual property, IP, in other areas, including image rights and rights related to the recently released biopic. Another example is Usain Bolt, who continues to be a well-sought-after brand with which companies wish to associate their goods and services. The monetary value of such examples is clear. However, the question remains, for a talent in the rough, an upcoming artiste, sportsman, or other creative alike, how can these persons extract value from their intellectual property? Further, how can financial institutions, venture capitalists, Jamaica's IP framework, and even the government help? What is the value of an up-and-comer's IP? And are we, as a society in Jamaica, aware of and serious about valuing IP? In answering these questions, strides have been made, particularly with the Jamaica Intellectual Property Office, JIPO, to push conversations about taking the value of IP seriously. These conversations have included dialogue with financial institutions about accepting IP as collateral for loans. However, there remains hesitation as these institutions tend not to see the value of the IP should they need to call on that collateral in the event of a default. This is not an unreasonable position until there is a shift in the perception of IP, where it is viewed as something serious and of economic worth. So, what is the value of it all? How can we seriously consider IP's fiscal value? This article offers a few very high-level suggestions. Understanding IP rights. If creatives and businesses are to take hold of the value in their works, it will be essential for them to understand what types of IP rights exist. Public education will be a key component here so people understand whether their works, such as novels, songs, or videos, are protected by way of copyright or whether their logos and brand names are protectable by trademarks. While these are the most popular in Jamaica, knowledge of other IP rights, such as designs, cultural knowledge, and patents, will also be important. Where an individual or business has any of these IP rights, these rights could, where exploited properly, be extremely valuable. Registering IP. One way to truly get the value out of IP and increase the value of the IP itself is to register it so that it is protected. In Jamaica, some IP rights, such as copyright, may attach as soon as a protectable work is created, whereas other IP rights, like trademarks, may get the best protection from being registered. As a rule of thumb, registration is best, and this means, in Jamaica, registering your IP with JIPO is the best option. Another benefit of registration is being able to establish ownership of the IP, which will be essential when it comes to exploiting the IP for financial gain. Noting IP as an asset. Individuals and businesses should have their IP valued and ensure that this value is noted as an asset to that person or business. For businesses, IP should be noted in the financial statements of the business as an asset. Keeping up with and exploiting IP. In order to gain value, IP must be used and exploited. This involves everyday use of, for example, a logo. For other forms of IP, using and exploiting IP may involve more focused activity, such as promoting listeners to a song or readers to a book. IP rights may also be licensed or assigned, which may increase their value and provide some income to the IP owner. Additionally, individuals and businesses need to keep good records of their IP and any valuation of the same and ensure that any required registrations are kept up to date. Conclusion. Looking seriously at the economic value of IP in Jamaica will not happen overnight. It will involve serious discussions at high levels, including talks on funding and public education, which is geared at shifting certain cultural norms which see creative ventures, which lead to IP, as either, on two ends of the spectrum, a frivolous thing or, at the other end, solely intellectual. Looking seriously at the economic value of IP will involve having creatives and businesses take the relevant steps to ensure that they are maximizing the potential of their IP, which will take much effort and hard work. These steps can start with individuals and businesses recognizing what IP they have, protecting that IP through registration and claiming ownership, recognizing that their IP has a fiscal value, and noting the same, and exploring ways to promote and exploit that IP in order to gain value for the individual or business, and the IP itself. When we establish a culture in which intellectual property has value and creative works are assets, we can have more fruitful conversations on monetizing those assets. Page 29. Segment. Empowering the Future of IP in Anguilla and the Caribbean. Sponsored by Severi Monsuarez, Caribbean. Page 30. Article. How my recent partnership with a global law practice positions me to provide exceptional services related to intellectual property law in the Caribbean region. Written by Keisha Fleming Lake, Managing Partner at Severi Monsuarez, Anguilla. In 2022, I launched my own practice of providing intellectual property, IP, law services in the Caribbean region to 29 different Caribbean jurisdictions. Under this firm, our services included registration of trademarks, re-registration of patents, domain name registration, and management of intellectual property portfolios, including recording of assignments, licenses, and changes in proprietor details. As a Caribbean national, I was proud of the fact that I could advise clients on these matters, understanding the cultural, legal, and political landscape of the region. A huge part of my practice emerged from the fact that I was called to the bar in multiple jurisdictions in the region and the fact that I connected with a network of IP professionals who supported the business model of my practice. It was important to connect with like-minded professionals from the Caribbean region. This was done through participation in events hosted by Caribbean legal associations, attending and volunteering at events for practitioners in the region, and connecting through other professional and personal events. In recent years, I have established a robust practice of providing IP services in the Caribbean region, and now acting as the managing partner to the Severi Monsuarez Caribbean office in Anguilla, I will continue to do so. Insert photo 1. The intricacies of the intellectual property law regime in the Caribbean region. The practice of intellectual property, IP, law in the Caribbean region is unique and is laced with a number of challenging features. Most of the time, the group of over 28 countries is referred to as one jurisdiction. It is often misunderstood as being governed by a blanket legislation with a standard approach covering all the countries. To the contrary, though, the region consists of about 29 jurisdictions, each with its own IP regime and independent legislative framework to cover intellectual property, IP, law and anti-counterfeit measures. The various IP rights laws and regimes in the Caribbean region continue to burden brand owners to follow strict requirements to protect their intellectual property. Throughout the region, IP offices are taking steps to simplify the process of filing for protection of valuable intellectual property. New legislation is being implemented in many jurisdictions, and in some others, progressive legislation has been drafted and is awaiting passage by their respective legislative bodies. Insert photo 2. Unique features of the Caribbean intellectual property laws and regimes. One of the distinctive features of intellectual property laws and regimes in the Caribbean region is that several jurisdictions operate under a manual filing system and require personal attendance at the Trademark Registry Office to conduct business. These jurisdictions still operate under legislation that is mostly outdated and not in line with the current practice of larger nations. Other significant exceptional features in some Caribbean jurisdictions include the requirement for application and supporting documents to have notarized wet ink signatures and, in some instances, legalization. Such unique and somewhat challenging features make the IP practice in the Caribbean special and attractive to me as a practitioner. What would be a challenge to practitioners not used to navigating an area like the highly diverse Caribbean region has become second nature to me as a Caribbean IP practitioner. The Caribbean is a melting pot of different geographical and political entities in close geographical proximity to each other. Many countries share similar political and legal systems and speak the same language, while others have distinctively different political and legal systems and speak different languages entirely, with practically all of them respectively maintaining independent IP laws. Insert photo 3. The impact of new IP legislation in the Caribbean. One may argue that the uniqueness that plagues the region is on a short lifespan due to the serial replacement of outdated IP legislation with more modern and progressive legislation across many of the Caribbean jurisdictions. It is obvious from a review of the new legislation in various territories in the Caribbean region that they aim to improve the requirements for filing for IP protection and bring their IP regime more in line with the modern world and larger nations. In recent years, there have been, and continue to be, changes in IP legislation in several Caribbean jurisdictions to make their IP regimes more modern and progressive. IP practitioners have long awaited such new legislation and eagerly anticipate the wider spread of modernized legislation across the rest of the region. Yet, despite the new laws being passed in some jurisdictions, legislation stubbornly remains largely untouched and filing systems are still outdated and manual in too many jurisdictions in the region. In the Bahamas, for example, the legislation has not been updated, and the old British classification system is still being followed. In Guyana, likewise, the legislation has not been updated in years. As a sole practitioner, providing services in a region like the Caribbean can present challenges. Manual filings, for example, can result in increased costs and an expenditure of time that may not be able to be passed on in billing. For me, the goal at all times is to service all clients with the highest degree of professionalism, effectively and efficiently, providing accurate advice and strategies that best suit the client's needs. Ensuring that clients' IP is protected, especially with trademarks, ensures that trademark prosecution is cost-effective and strategic. Trademark prosecution and enforcement and patent filing comprise a large part of our regional IP practice. A practice of advising clients on effective strategies to ensure the enforcement of anti-counterfeit measures on behalf of our clients is also emerging. The issue of importation, sale, and widespread distribution of counterfeit goods is of global concern and also of concern to the Caribbean, where consumers are experiencing the ramifications of this practice. Not every island in the Caribbean jurisdiction is a known destination for counterfeit goods. Still, the close geographical proximity between the island nations and the improvements in shipping and transportation between the markets make the counterfeit issue an overall concern for the region. Insert photo 4. Partnership with a global practice provides the necessary support to continue providing an effective service to clients. My decision to partner with a firm with a global IP practice results in my being better able to provide the necessary support to continue providing an effective service to clients. The strategic alliance allows me to focus on advising clients with the support of a large team of knowledgeable and experienced professionals in the IP world. A firm with a global presence focusing on providing services to clients of all sizes has the necessary collection of diverse skills needed to take on the challenges the Caribbean IP practice presents. What this means for my current and future clients is a continuation of the same high-level service and a more comprehensive suite of IP services to navigate the challenging landscape in the Caribbean region. Page 33. Article. Interview with the EAPO President, Dr. Grigory Ivliev, on the 30th anniversary of the Eurasian Patent Convention. Dr. Alexey Vakhnin of Vakhnina and Partners sits down with Dr. Grigory Ivliev to give you an insightful interview regarding the anniversary of the Eurasian Patent Convention and the developments of the Eurasian Patent Office. Author bias. Dr. Grigory Ivliev is the president of the Eurasian Patent Office, EAPO. He was formerly the head of the Federal Service for Intellectual Property, Rospatent. The Eurasian Patent Office, EAPO, is an executive body of the Eurasian Patent Organization, administering the regional patent registration system covering 8 countries of the Eurasian region. He objects to IP rights protection for inventions and industrial designs. Member states: Armenia, Azerbaijan, Belarus, Kazakhstan, Kyrgyzstan, Russia, Tajikistan, Turkmenistan. Dr. Alexey Vakhnin is partner and managing director of Vakhnina and Partners, a Russian and Eurasian patent and trademark attorney firm. He is a Eurasian patent attorney and patent and trademark attorney of the Russian Federation with extensive experience in IP since the 1990s. Having a Ph.D. in medicine, biochemistry and immunology, while working on patent matters, Alexey specializes in medicine, biotechnology, biochemistry, and pharmacology. Dr. Vakhnin is a member of the Eurasian Patent Attorneys Assembly, EPAA, FICPI, AIPPI, LACI, INTA, ECTA, PTMG, etc. September 9, 2024, will mark the 30th anniversary of the signing of the Eurasian Patent Convention, an international treaty establishing the Eurasian patent system. The Eurasian Patent Organization unites 8 countries: Armenia, Azerbaijan, Belarus, Kazakhstan, Kyrgyzstan, Russia, Tajikistan, and Turkmenistan. The Eurasian Patent Office is an executive body administering the regional system of legal protection of inventions and industrial designs on the basis of a single Eurasian patent. Opening remarks by Alexey Vakhnin. The 30th anniversary of the Eurasian patent system, which is celebrated this year, 2024, is an important date for the intellectual property of all countries in the region. I visited the Eurasian Patent Office for the first time as a student. I was lucky enough to see the growth and development of this international organization. At that time, it did not even occur to me to dream that one day I would become a Eurasian patent attorney. I was lucky to study at numerous seminars and lectures held by the EAPO many years ago. Later, I met the first president of EAPO, Dr. Viktor Blinnikov, and the following presidents of the EAPO, Dr. Alexander Grigoriev and Ms. Saul Tlevlasova. Over the past 30 years, the Eurasian Patent Office has shown serious professional growth and strengthened its position among other patent offices and consolidated the highest quality of expertise and office work, which for many other patent offices in different countries is a level to which one should strive. Therefore, it is a great honor for me to ask questions and present an exclusive interview for the Global IP Matrix magazine with the president of the EAPO, Dr. Grigory Ivliev. What does this anniversary mean to you? Dr. Grigory Ivliev. The anniversary is a good opportunity to remember the history and the people who initiated the establishment of the Eurasian patent system and to look to its future. The founders of the Eurasian Patent Convention, EAPC, and the Eurasian Patent Organization are greatly appreciated and respected by the officials of the Eurasian Patent Office. We first pay tribute to the honorable memories of Dr. Viktor Blinnikov, the first president of the Eurasian Patent Office, and Dr. Arpad Bogsh, WIPO Director General. The process of EAPC drafting and signing could have been significantly delayed without his support. Dr. Bogsh's diplomatic talent helped to successfully complete not only the preparation of the convention but also its signing and ratification by the contracting states. It is important to acknowledge the efforts of our colleagues from the European Patent Office, who shared their experience throughout the EAPC preparation process and contributed to the development of the Eurasian Patent Office. We can evaluate differently whether 30 years is a significant term. But we have achieved a lot during these years. We have managed to establish a modern regional patent office with a high level of examination. A diverse team of professionals was assembled, competent to deal with the challenges of the time. Currently, we have a competent digital patent office that meets all modern examination and information technology requirements. How do you evaluate the evolution of the EAPO over 30 years? We are proud of the significant growth our organization has experienced since 1994. One of the main reasons for the establishment of the EAPO was the lack of IP protection capacities in almost all independent states that emerged after the collapse of the USSR. There were neither searchable patent information funds nor qualified patent examiners to examine applications for inventions. Each EAPO member state currently has its own patent system and national patent office. At the same time, the EAPO has been working and developing steadily. Following a period of formation and accumulation of its patent office's expertise, we are currently engaged in a new phase of the organization's development, including expanding its competencies and functions. Protocol to the Eurasian Patent Convention on the Protection of Industrial Designs, which expanded the mandate of the organization, was signed 5 years ago. Since June 1, 2022, the Eurasian Patent Office has accepted industrial design applications. The system has retained all the advantages of the centralized procedure for obtaining protection. It is still under development, but the geography of applicants has expanded to 26 countries within a short period of time. The Eurasian Patent Office started functioning as an international searching authority and an international preliminary examining authority under the Patent Cooperation Treaty, PCT, in 2022. The acknowledgement of the high quality of the examination and the office's work is a milestone for us. We are advancing projects with the EAPO member states to develop a common information and examination space, improve the efficiency of examination, and incorporate advanced digital tools into our work. Why do you think the Eurasian patent system has proved to be sustainable and successful? This is primarily because the Eurasian patent system is a business-driven instrument. The regional tool of legal protection diminishes trade and economic barriers caused by the territorial nature of IP rights. The common patent space is also relevant because 5 out of 8 EAPO countries are members of the Eurasian Economic Union, which has its 4 freedoms space. The Eurasian system is the most appropriate option for those who need protection in several countries at once. Secondly, the Eurasian patent system is very flexible. A Eurasian patent is valid once granted in all member states without additional validations and translations. Our straightforward and cost-effective procedure requires filing only one application in one language and paying one set of fees. The patent for an invention can be maintained only in those countries that are of business interest. The third essential factor is the quality of the Eurasian patent. The EAPO is an independent intergovernmental organization. We can attract the best professionals from all member states. Panels of examiners from different countries make decisions on each patent. The professional team helps to strengthen the quality management system. A friendly team of multilingual specialists from different countries and confessions has been assembled. They have a good knowledge of the development process and the specifics of the patent systems in the EAPC contracting states. This diversity is undoubtedly our strength. Last year, we launched a fellowship program to expand the number of young examiners from the countries least represented in the EAPO. As for the diversity, I also want to mention that the proportion of female employees exceeds that of men. Women are well represented in leadership positions. What other measures has the Eurasian Patent Office taken to ensure the quality of the examination? The provision of high-quality services is a priority aspect of our development program until 2028. The Eurasian Patent Office has adopted the necessary regulatory documents and formed specialized divisions for both internal and external control as well as for continuous monitoring to implement a comprehensive quality management policy. We adhere to the highest international standards in our work. I would like to emphasize that the development of the user feedback system is an important element of quality. The Assembly of Eurasian Patent Attorneys was established in April 2023. For the Eurasian Patent Office, it is a valuable information source from the professional community and a platform for discussing consolidated views on the development of the Eurasian patent system for the benefit of users. We are developing a new integrated information system that will simplify online interaction with users of our services and administrative processes in the Eurasian Patent Office. We are upgrading our information systems to make electronic services as convenient as possible and in accordance with applicants' needs. Does the geopolitical situation affect the Eurasian Patent Office's quality of work? No, the patent examination has not undergone any changes. Despite a lot of fake news, I can confidently state that we are still entirely fulfilling our commitments to applicants and rights holders from all countries in strict compliance with international treaties governing IP protection. I have repeated my position many times on different international platforms. I strongly believe that the IP system must remain exclusively within the legal framework. Any discriminatory measures in the IP field are destructive and cause legal uncertainty. In 2022 and 2023, the number of applications to the Eurasian Patent Office remained stable. The structure of applications remained the same. Applicants from the United States and European countries continued to be among the top. What fields of technology are most often patented? As in recent years, applications for inventions in the fields of organic chemistry, pharmaceuticals, and medicines accounted for the largest number of Eurasian applications in 2023. Medicine and pharmaceuticals are the fields in which patent protection is of particular importance. Within its mandate, the Eurasian Patent Office is developing the Eurasian Pharmaceutical Register, as a source of information on the exclusive rights to inventions related to active pharmaceutical ingredients. It includes both Eurasian and national patents. Regulations on the Eurasian Pharmaceutical Register were adopted in December 2023. It identifies possible mechanisms for determining the legal status of information contained therein. With due regard to the requirements of national legislation, the member states will determine whether to use information from the Pharmaceutical Register as official. You have mentioned the development program until 2028. What kind of document is it, and what aspects of the EAPO's functioning do you find most important? It is a medium-term planning document. In May 2023, the Administrative Council, which serves as the EAPO governing body and comprises the heads of the IP offices of the EAPO member states, approved the EAPO development program. The document includes 8 main development areas. In addition to improving the quality standards of the office's products and services, the office will keep working towards the formation of a common Eurasian information and examination space. The aim is to ensure the highest possible harmonization level of approaches to granting patent protection. Specifically, the Eurasian Patent Office has developed the EAPPH Patent Prosecution Highway Program in cooperation with the patent offices of the EAPO member states. An Eurasian project was developed to electronically exchange copies of priority documents when seeking priority under the Paris Convention for the Protection of Industrial Property. Apart from the traditional objectives that offices address under the PPH, namely, to reduce duplication of patent search and examination work and to reduce costs for offices and applicants, the EAPPH program is a basis for harmonizing substantive examination approaches throughout the region and sharing best examination practices across Eurasia. Furthermore, we are implementing projects related to cooperation in the fields of search and examination of inventions. They include agreements on patent search and preparation of patentability reports by EAPO examiners at the request of national offices of the EAPC contracting states. Finally, we launched a patent outsourcing project. Upon accreditation, leading scientific and educational organizations of the Eurasian region are eligible to participate in this project to conduct patent searches and prepare reports on the patentability of inventions in specific fields of technology, in which such organizations' high scientific and professional expertise is confirmed. This ensures the quality and reliability of granted patents for inventions valid across the Eurasian region. The program also highlights the digitalization of the EAPO, which includes the introduction of modern approaches using big data technologies, artificial intelligence, machine learning, etc. Moreover, The development program envisages the development of the pharmaceutical register, expanding international cooperation, and developing educational projects, which EAPO implements jointly with the member states. Some ambitious objectives include expanding the Eurasian system to include the Eurasian trademark and utility model and improving the dispute resolution system regarding IP objects with the regional scope of protection. Overall, the Eurasian patent system has proven to be the most effective in its 30 years of functioning. The Eurasian Patent Office will continue to strive for its further dynamic development with the EAPO member state support. Dr. Alexey Vakhnin, Dr. Ivliev, thank you for your detailed and informative interview. At the end of the interview, I wish the Eurasian Patent Office further professional growth and development, an increase in the number of participating countries, and a growth in the number of applications filed and patents registered. I hope that in the near future, we will also see the development of new directions in the registration of utility models and perhaps even Eurasian trademarks. Once again, I congratulate you on EAPO's 30th anniversary and wish you and your team all the best.
Page 37. Advertisement. Vakhnina and Partners, Russia. Eurasian and Russian patent and trademark attorneys. Trademarks, patents, utility models, designs. Dr. Tatiana Vakhnina, Dr. Alexey Vakhnin, and Dr. Elena Ivanishkina. EAPO, Armenia, Belarus, Kazakhstan, Azerbaijan, Georgia, Moldova, Armenia, Russia, Kyrgyzstan, Tajikistan, Turkmenistan, Uzbekistan. Trademarks, trademark search, trademark prosecution, trademark monitoring and trademark litigation. Contact. Russia, ip@vakhnina.com. Armenia, am@vakhnina.com. Kyrgyzstan, kg@vakhnina.com. www.vakhnina.com. Tel +7 495 946 7075.
Page 38. Article. Protection of Computer, Software Programs in Sri Lanka. Written by Anomi Wanigasekara, partner, and Sabira Sharif, senior associate at Julius & Creasy, Sri Lanka. In the modern digital economy, computer and software programs are considered valuable assets, necessitating the protection of intellectual rights attached to such creations. Multiple intellectual property rights, IPR, could be employed to protect IPR in computer and software programs to secure the value they generate. Today's businesses follow complementary IP strategies rather than focusing only on one aspect, which is considered a wise move in view of the emerging business risks. The Intellectual Property Act, No. 36 of 2003, IP Act, governs all aspects of intellectual property in Sri Lanka. Sri Lanka is a signatory to many key international instruments related to IPR, including the Paris Convention for the Protection of Industrial Property, the Berne Convention for the Protection of Literary and Artistic Works, the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, and the Patent Cooperation Treaty. In Sri Lanka, computer programs shall be protected as literary, artistic, or scientific work, which are original intellectual creations in the literary, artistic, and scientific domain under Section 6(1) of the IP Act. Also, databases are protected as derivative work under Section 7(1). Article 10 of the TRIPS Agreement also accords with copyright protection for computer programs, whether in source or object code, as literary works under the Berne Convention. In the international context, the position in the United Kingdom is that computer programs must be original to obtain copyright protection, and there must have been a modest amount of skill, labor, or judgment involved in its creation. In Europe, a computer program will be protected if it is the author's own intellectual creation and no other criteria are required. In this context, copyright is an aspect a business could consider. There is no legal requirement to register a copyright in Sri Lanka. However, copyright is subject to certain limitations provided in the IP Act. Copyright is protected during the author's lifetime and for 70 years from the date of his death. However, there will be no protection against independent creations. There will be mere protection of the expression, not the algorithm. Therefore, a software developer can use different programming languages without violating the copyright of another. In terms of the IP Act of Sri Lanka, inventions are deemed to be patentable if such inventions are new, involve an inventive step and are industrially applicable. However, there are specific items which are excluded from the patent regime in Sri Lanka. Section 62(3)(a) of the IP Act deals with excluded subject matter, and business methods are excluded subject matter. However, unlike in India, where Section 3 of the Indian Patents Act, 1970, clearly prohibits the patenting of software per se, in Sri Lanka, computer software programs are not likewise specifically excluded from patent protection. Therefore, it is arguable that if the criteria of patentability, i.e., novelty, inventive step, and industrial applicability, are met, then computer software programs may be allowed patent protection provided those are not excluded subject matter under the IP Act. There are many benefits in obtaining patent protection for computer software programs as the functionalities of the software will be protected. A registered patent creates a monopoly for 20 years in Sri Lanka. In the international sphere, the U.S. Supreme Court's decision in Alice Corporation v. CLS Bank 1 preserves software patentability but requires an inventive concept to transform the abstract idea into patentable subject matter. According to the European case law jurisprudence, technical character is crucial in software patentability. The questions to be answered are: is there an invention? And does the claimed subject matter have a technical character? The approach in the United Kingdom is evident in Aerotel v Telco Holding. Point 2 Lord Justice Jacob set out a four-stage assessment inter alia involving the evaluation of whether the actual or alleged contribution is actually technical in nature. The Aerotel approach has been reaffirmed in Apple Inc. v HTC Corporation 3 case, by reference to European case law, emphasizing that the technical effect approach should lead to the same result. These matters are still open for debate under the Sri Lankan legal regime, and the Sri Lankan courts will have to interpret the patentability of computer software programs in light of this international key jurisprudence. However, patent protection is generally considered stronger concerning computer software programs than copyright. Many other IP tools may be employed to protect computer software programs, such as industrial designs, which may be utilized to protect the graphical user interface, graphic symbols, especially the visual aspects, provided it meets the legal criteria required for protection, trade secrets, trademarks in relation to branding, provisions relating to unfair competition, domains, etc. Many businesses now focus on ownership models rather than the traditional license agreements to exploit the software. Therefore, exploring these options to protect computer software programs in Sri Lanka is important, as the current high-tech business world substantially depends on software developments.
Page 40. Advertisement. Intellectual Property Law Association. IIPLA, 2024 USA. October 1st to 2nd, 2024. Palo Alto, California. Discover exceptional intellects.
Page 41. Article. Disclaimer: images and reference links related to this article can only be seen in the digital and printed editions of this magazine. The Future of Mobility, a three-way race between hybrid, hydrogen, and electric propulsion. Written by Dean Parry, Technical Director, and Claire Gibson, Senior Patent Analyst at PatWorld, UK. Author bias. Dean Parry, the Technical Director at PatWorld, has accumulated over 18 years of expertise in the innovation of search techniques for patents, designs, and research journals. His leadership emphasizes quality, cost efficiency, and client-centric strategies. Under his guidance, expert search teams have successfully executed over 25,000 searches, covering various fields, including biotechnology, automotive, and software. Claire Gibson is a multifaceted senior patent analyst at PatWorld Limited, UK, with a BSc in physics and expertise in femtech, optics, semiconductors, and electronic instrumentation. She champions climate change, diversity, and empowerment of minorities while excelling in patent search and analysis, regularly contributing insightful articles on femtech and other topics, and maintaining a balance between her professional commitments and her passions for hiking and literature. As we navigate the crossroads of automotive innovation, the race for the future of mobility has broadened to include not just the traditional combustion engine but also hybrid, hydrogen, and electric engines. This pivotal moment echoes the early days of the automobile, where myriad technologies competed for dominance before petrol became the standard. Today, however, the competition is spurred by an urgent need for sustainability and environmental preservation. Recent research and expert insights. Hydrogen engines have emerged as a promising net-zero greenhouse gases emission alternative, generating power by combining hydrogen with oxygen and emitting nothing but water. This technology offers a glimpse into a future where vehicles play a positive role in environmental sustainability, potentially revolutionizing industries beyond personal transportation. Patent application activity is sampled via B60K 2015 U03315 for hydrogen and Y02T9040 application of hydrogen technology to transportation, e.g., using fuel cells, with a specific focus on the application within the field of vehicles. As shown below in Figure 1, created via PatWorld, the sample highlights the emergence of hydrogen as a green alternative for vehicle propulsion, with a notable increase in patent application family activity from 2019 onwards. It should be noted the drop observed in 2022 to 2023 is explained by the delay due to the 18-month publication cycle. However, the path to a hydrogen-powered future faces infrastructural and economic hurdles. This includes the need for comprehensive production, storage, and distribution networks in a bid to combat such obstacles surrounding the effectiveness of hydrogen power as a viable option. Specifically, referring to the drawback of the high carbon emissions associated with producing hydrogen from natural gas, we look to Y02T90 enabling technologies or technologies with a potential or indirect contribution to GHG emissions mitigation, focusing on Y02E60 or 30 hydrogen technology. This classification, as seen in Figure 2 below, created via PatWorld, shows an upward trend in patent application activity, specifically beginning in 2018. This illustrates the race to realize effective and attainable hydrogen technology as a potential primary clean technology option going forward. Once again, the delays due to the 18-month patent publication cycle account for any discrepancy seen in 2022 to 2023. Despite these challenges, the environmental and energy independence benefits position hydrogen as an enticing long-term solution. Countries such as Europe and Japan are in the lead in creating clean technologies, according to a new joint study of hydrogen technology patents by the European Patent Office, EAPO, and the International Energy Agency, IEA. 1. Simultaneously, electric vehicles, EVs, have made significant strides, driven by advancements in battery technology, energy density, and charging infrastructure. EVs offer an immediate reduction in greenhouse gas emissions, particularly when integrated with renewable energy sources. The advantages of electric propulsion include instant torque and improved performance. Electric motors deliver instant power, improving vehicle acceleration and driving dynamics. Energy efficiency. EVs convert a higher percentage of electrical energy from the grid to power at the wheels, surpassing hybrid and traditional engines in terms of energy efficiency. Reduced emissions. With zero tailpipe emissions, EVs play a crucial role in reducing air pollutants, leading to cleaner cities and a decrease in greenhouse gas emissions. Lower operating costs. Electricity can be more affordable than petrol or diesel, and EVs, with fewer moving parts, incur lower maintenance costs. It is no news that patent activity within the field of electric vehicles, EVs, has been high in recent years. Car manufacturers have brought an increasing amount of electric vehicles to market recently, and currently, in the UK, it is estimated there are over 1.02 million battery electric vehicles on the roads and approximately 615,000 plug-in hybrids, too. The classification B60L*, which covers electric vehicles, propulsion of electrically propelled vehicles, supplying electric power for auxiliary equipment of electrically propelled vehicles, electrodynamic brake systems for vehicles in general, magnetic suspension or levitation for vehicles, monitoring operating variables of electrically propelled vehicles, electric safety devices for electrically propelled vehicles, along with Y02T10/62 hybrid vehicles and B60W20** control systems specially adapted for hybrid vehicles, displays the increased patent activity, with countries such as China, the United States, and Germany leading the way, as seen in Figure 3, created via PatWorld. Hybrid vehicles bridge the gap between traditional combustion engines and the future of electric mobility, combining internal combustion engines with electric propulsion. This allows for reduced emissions and improved fuel efficiency, making hybrids a practical step towards cleaner transportation. The flexibility of hybrid vehicles to utilize existing fuel infrastructure while benefiting from electric propulsion makes them an appealing transitional technology. The road ahead. Experts believe that a single technology will not dominate the future of mobility but will instead be shaped by a mix of solutions tailored to different needs and contexts. The coexistence of hybrid, hydrogen, and electric engines underscores a diversified approach to achieving sustainable mobility. Breaking down electric vehicle, EVs, and hybrid vehicle classifications used in Figure 3 to represent a cross-link hybrid of such vehicles also incorporating hydrogen in a mixed combination coexistence, countries are already considering such mixed solutions to fuel vehicles. As shown below in a word cloud style chart in Figure 4, created via PatWorld, when discussing electric or electric hybrid vehicles, alongside the intermixed usage of hydrogen, the focus appears to disclose the integration of combined sources to fuel, operate and energize the field of clean technology applications of vehicles. As we move forward, the dialogue among industry professionals, policymakers, and consumers will be instrumental in navigating the complexities of this transition. The collective aim is clear: to forge a path towards a sustainable, efficient, and accessible transportation ecosystem. Engage in the conversation. The advancements in hybrid and electric technologies, alongside the potential of hydrogen, signify an exciting phase in automotive history. As professionals in the field, our insights and decisions will steer the evolution of transportation. What are your thoughts on the electrification of transportation, the role of hydrogen, and the future of hybrid engines? How do you envision these technologies shaping our journey toward sustainable mobility?
Page 45. Advertisement. EAPO. Eurasian Patent Office. Patent application. Language. Set of fees. Examination. Patent attorney. Inventions. Industrial design. Eurasian patents, 8 states. International Searching Authority. International Preliminary Authority. Eurasian Patent Office. www.eapo.org. info@eapo.org.
Page 46. Article. The Eurasian Pharmaceutical Register, an instrument for pharmaceutical companies. Written by Mrs. Aurelia Sieben, Deputy Director of the Examination Department and Head of the Chemistry and Medicines Division at the Eurasian Patent Office, Russia. The Eurasian Pharmaceutical Register is a unique information resource that consolidates data on patent rights to active pharmaceutical ingredients, API, having international non-proprietary names, INN, the legal status of such patents, registered medicinal products, and license agreements concerning the above-mentioned API on the territory of 8 Eurasian Patent Convention, EAPC, contracting states. The Pharmaceutical Register is formed and maintained by the Eurasian Patent Office, EAPO. The Pharmaceutical Register was created in 2021 to inform interested parties about the exclusive rights to API-related inventions protected in the Eurasian patent space. Initially, it contained information only on Eurasian patents. In 2022, its scope was expanded by adding national patents due to the interest of the EAPC contracting states in this resource. The Pharmaceutical Register is a publicly available information resource that provides free access to the information contained therein. It includes Eurasian and national patents for inventions protecting API, namely, patents for chemical compounds, biotechnological products, processes of production of such products, since the process provides indirect protection to the obtained product, new combinations, and medical uses of API. The information in the Pharmaceutical Register is grouped by INN, allowing searching by patent number, name of patent holder, and INN. It includes comprehensive, up-to-date information on the legal status of the patent, specifying its validity on the territory of each EAPC contracting state, patent term extension, lapse of the patent due to non-payment of maintenance fees or its invalidation on the territory of any state. The patent included in the Pharmaceutical Register is directly linked to the Eurasian Patent Register on the EAPO website, where users can find detailed information on the legal status of the patent, including transfers of rights, as well as the patent specification containing claims. Information is included in the Pharmaceutical Register at the request of patent owners. However, the EAPO may also enter information on Eurasian patents involving registered medicinal products on the territories of the EAPC contracting states. It aims to provide more complete information on patent rights in view of the informational nature of the register. It is worth noting that the inclusion of Eurasian and national patents in the Pharmaceutical Register, as well as amendments and addenda to the information contained therein, is carried out following the examination conducted by the EAPO. It ensures verification and high quality of the information contained in this information resource. The examination involves compliance of the patent-protected subject matter to the appropriate INN. It is carried out by leading examiners from 8 EAPC contracting states since it requires highly specialized qualifications in the fields of chemistry and biotechnology. This guarantees the accuracy of the information contained in the Pharmaceutical Register. This resource is in high demand among patent owners for both Eurasian and national patents. As of April 1, 2024, the Pharmaceutical Register contains information on 359 Eurasian and national patents related to 235 INs and their combinations. The EAPO Administrative Council approved new regulations on the Eurasian Pharmaceutical Register on December 7, 2023, in order to expand the possibilities of using the information contained in the Pharmaceutical Register. These regulations stipulate the legal status of data in the Pharmaceutical Register as reliable, up-to-date, systematized, and publicly available. Most importantly, it offers the option to recognize such information as official in order to attest to the patent protection of API on the territory of the EAPC contracting state. Possible mechanisms for recognizing this information as official are also provided, for example, under an agreement concluded between a contracting state and/or an international intergovernmental organization to which the contracting state is a member and the Eurasian Patent Organization. The information included in the Pharmaceutical Register and recognized as official by the EAPC contracting state can be used on its territory in enforcement procedures of patent rights to API-related inventions, including in the adoption of provisional measures under the national law of the contracting state. The EAPO provides extracts from the Pharmaceutical Register certifying the protection of API on the territory of the state to any person upon their request. These extracts can also be provided at the request of judicial and other competent authorities of the states. The extract contains information on the compliance of the patented subject matter with a specific INN or combination of INN, indicating the claims of the Eurasian or, respectively, national patent protecting the API. Therefore, this Pharmaceutical Register presents an additional tool for patent owners to enforce their patent rights. It also represents a source of reliable and up-to-date information for a wide range of pharmaceutical market players, ranging from API developers to those engaged in the registration of medicines and their introduction into the market.
Page 48. Advertisements. Advertisement 1. Life Sciences Strategy Summit on IP and Exclusivity. 8th to 10th October in Munich, DE. Register your interest today at lsstrategysummit.com. Advertisement 2. IP Biopharma Live. 10th to June 14th, 2024 virtual. Register your interest today at Global Biologics Cell and Gene Legal Summit/agenda.com. Final advertisement. IPO Annual Meeting 2024. September 22nd to 24th. 2024 at Hyatt Regency Chicago, IL. CLE Credit, Networking, Fun Run/Walk, Receptions, Expo Hall and more. For more info or to register, visit www.ipo.org/am2024.
Page 49. Article. Digital Media Piracy and Copyright Enforcement, Effectiveness of Copyright Enforcement Mechanisms in Nigeria and Other African Countries. Written by Ike B. Abeku, partner at Benchmark and INTA, Nigeria. Introduction. Over the years, there has been a proliferation of online content that serves to either entertain or educate users and, in some cases, both. These contents come in various forms, including blog posts, movies, skits, musicals, and social media posts. In addition to being used to entertain and educate, digital content is also used by e-commerce merchants to market their products and services. It is a little wonder that content is king. Whether created for fun or economic reasons, content must be protected against piracy. In this regard, the Nigeria Copyright Act 2022, the Act, was heralded for giving gusto in the provision of a legal framework and mechanism for combating piracy in the digital space. Prior to the enactment of the Act, online creatives, content creators were left with little to no remedy against the infringement of their intellectual property rights. Whereas the hitherto existing law, the Copyright Act of 1988, made provisions against piracy, it focused more on tangible or physical works such as books. This article will analyze the effects of online piracy on Nigeria's creative industry alongside the effectiveness of available anti-piracy measures. Challenges posed by piracy to Nigeria's creative industry. At the 2019 World Intellectual Property Day event held at Abuja, the Director General, DG, of the Nigerian Copyright Commission, NCC, the body responsible for regulating the copyright industry and enforcing the Copyright Act, disclosed that Nigeria loses NGN 918 trillion, $3 billion, annually to the activities of pirates. 1 In the years preceding the promulgation of the Act and even after it came into force, creators of several copyright-eligible works faced several challenges, resulting in substantial economic losses. Last year, NetNeja, a popular free-to-air streaming and movie download website where users can stream movies directly or download them to their devices and view them later, shut down its movie streaming services. A statement released by the platform on its X account read thus: "It was quite a ride while it lasted. It breaks our hearts to break the hearts of our esteemed visitors with this action. We have always pushed it back, but unfortunately, we will be going ahead this time." The reason NetNeja was shut down was not disclosed. However, it was alleged that the platform pirated the movies it hosted. Copyright holders in movies hosted on NetNeja can only heave a sigh of relief while counting their losses, potentially running into millions of dollars. NetNeja was not only hosting foreign movies, producers of Nollywood 2 movies also has a fair share of the story to tell. Blood Sisters, a movie produced by Moa Budu that premiered in 2022, was uploaded to NetNeja. Movies like King of Boys, Return of the King and many other Nollywood productions could also be watched on this platform. In addition to NetNeja, the average Nollywood movie producer has other streaming platforms such as 02 TVs and Movies Joy, 2FZMEs, TFPDL, and TopNow. Set to worry about. Explaining the challenges faced by regulatory agencies in curbing the activities of pirates in Nigeria, the DG of NCC, John Asane, stated that the expansion of high-speed internet around the world, the proliferation of portable devices and the rise of online streaming platforms had made tackling illegal exploitation of rights more difficult. 3 He further stated that thousands of websites that illegally stream sporting and entertainment content in real time threaten the copyright in the content. For the enormous economic losses occasioned by piracy discourage and disincentivize creativity. Movie producers and copyright owners are racing against pirates to reap the benefits of their hard work and mental efforts. Investors, on the other hand, are developing cold feet. The primary purpose of intellectual property laws is to ensure that creators of eligible works enjoy the economic and other benefits of their works by exploiting the same. Piracy in any form or manner defeats this purpose. Anti-piracy under the prior Copyright Act 1988. The previous Act provided for anti-piracy measures 5. Subsection 1 of that section gave the NCC power to designate any design, label, mark, impression, or other anti-piracy device to be used on, in or in connection with a copyrighted work. However, this power can only be exercised with the Minster S6 consent. Any person who sells, rents, hires, or offers for sale, rent, or hire any work in contravention of the subsection 1 above is liable to a fine not exceeding NGN 100,007 or for imprisonment for a term not exceeding 12 months or both. A proper analysis of the provision would reveal that the legal draftsman did not avert his mind to piracy over the Internet. Granted, the previous act was made in 1988, a time when most social networking sites and streaming services were not in existence. The need for a robust framework has been on the rise since 1988. The Act was promulgated to address this need. Mechanisms and measures introduced in the Copyright Act 2022 to combat piracy. The Act filled the lacuna in the previous Act by prohibiting the circumvention of technological protection measures and the falsification of rights management information. It also provides for takedown notice and the role of the service provider when such notice is issued. The term technological protection measure means a technology, device, product, or component designed to effectively prevent or inhibit the infringement of any copyright or related right. 8. It is prohibited to circumvent a technological protection measure while accessing digital content. It also prohibits the manufacturing, importation, sale or offer for sale of a technology, product or service whose purpose is to circumvent a technological protection measure. In this regard, a minimum fine of NGN 100,000 or a minimum term of 5 years imprisonment or both was imposed. Rights management information, RMI, on the other hand, refers to any information which identifies a work, the author or owner of any right in it, attached to or appearing in connection to the communication of the work to the public. The Act protects an author's RMI by prohibiting the concealment, alteration, or removal of the same and also prohibiting the sale of works bearing falsified RMI. A copyright holder whose rights have been violated in connection with his RMI and technological protection measures may sue for damages, accounts, or injunction. 9. Regarding the takedown notice provisions in the Act, a copyright holder who alleges infringement is required to issue a written notice to the service provider on whose platform the infringing content is hosted, requesting that the content be taken down. The service provider is duty-bound to notify the alleged violator, subscriber, of the takedown notice and its content, take down or disable access to the content, and notify the copyright owner. If the service provider receives a written counter-notice from the subscriber, the service provider is expected to forward such counter-notice to the copyright owner promptly. If no response is received from the copyright owner within 7 days, the service provider may restore the content it had taken down. A subscriber aggrieved with the actions of the service provider may have recourse to the NCC. A service provider who fails or refuses to take down infringing content is in the same position as the original infringer regarding the infringing content. NCC is also empowered to block or disable access to any content, link or website hosted on a system or network which it reasonably believes to infringe copyright under the Act. Areas for improvement. It has been 2 years since the Act came into force, however, its impact on online piracy is still to be felt. Granted, the Act provided robust measures and mechanisms for curbing online piracy, but a lot must be done in the area of enforcement. Comparison with other African countries. Kenya. Online piracy is as rampant in Kenya as it is in Nigeria. In the movie industry, for instance, it deprives creators of royalties they would have earned through authorized film distribution. Partners Against Piracy, PAP, a multisectoral association established to fight digital piracy, estimates that online piracy costs Kenya's creative economy approximately 92 billion Kenyan shillings annually. 10. The Kenya Copyright Board, KECOBO, launched the Anti-Piracy Security Device, APSD, a unique barcode applied to original video and audiovisual works to distinguish them from pirated copies. In addition to the APSD, the Copyright Amendment Act 2019 provides for the issuance of takedown notices and the corresponding role of Internet service providers. In 2022, the High Court of Kenya ordered ISPs to block sports pirate websites infringing on copyrighted material. This is a consequence of a suit filed by MultiChoice Kenya against Safaricom plc and Jamii Telecom Limited, seeking an order to compel the ISPs to block live sports streaming sites on their networks. 11. Egypt. According to estimates, the Egyptian creative industry loses millions of US dollars annually to online piracy. The Egyptian Intellectual Property Law No. 82 of 2002 is the primary law protecting intellectual property rights in the country. Additionally, there are regulations specifically targeting digital piracy. These regulations enable copyright holders to report copyright violations to the regulators and empower the regulators to take action against infringing websites. In 2022, the Being Media Group, in collaboration with the Alliance for Creativity and Entertainment, shut down 4 major illegal live sports operators in Cairo, Gol Arab. Com, Yaloshut 7 SRY. Com, Yaloshut. Us, and Yaloshut News. Com. The websites were visited by more than 4.8 million users annually. Page 52. Women's IP World Bite Size. This segment is sponsored by Barrister Bijuka Mildred Alugu and Bijuka Ivliev IP Sal. Ms. Bijuka Mildred Alugu, an experienced lawyer specializing in intellectual property, has dedicated over 15 years to the practice of IP law. She commenced her career at Spoor and Fishers with Incorporating Engwafa and Partners in Yaoundé, Cameroon, a firm renowned for its expertise in all aspects of intellectual property law. Ms. Alugu currently serves as a principal at Bijuka and Partners, a multidisciplinary law firm offering services in litigation, alternative dispute resolution, business law, and intellectual property under Bijuka Ivliev IP Sal. Since 2014, the firm has been unwavering in its commitment to honesty, integrity, and client satisfaction, prioritizing adherence to legal norms, professional ethics, and client welfare. Sponsored by Bijuka and Partners Law Office. Advancing women in IP law, breaking barriers, promoting inclusivity, and empowering excellence. Page 53. Article. Navigating Intellectual Horizons, a conversation with Barrister Bijuka Mildred Alugu. Barrister Bijuka Mildred Alugu is managing partner at Bijuka and Partners Law Office, Cameroon. In this insightful Candé segment, our editor, Elvin Hassan, engages in a dialogue with Barrister Bijuka Mildred Alugu, a distinguished figure in the realm of intellectual property law. From pivotal career moments to the intersection of gender diversity and innovation, delve into the multifaceted world of IP law with a seasoned expert. Hello, and thank you for sponsoring this important segment, Barrister Bijuka. Please introduce yourself and share with us a pivotal moment in your career within the realm of intellectual property law that shaped your approach or perspective. My name is Barrister Bijuka Mildred Alugu. I am a lawyer specializing in intellectual property, herein referred to as IP, and have been practicing IP law for over 15 years. I started my career as an IP lawyer with Spoor and Fishers Incorporating Engwafa and Partners in Yaoundé, Cameroon. This firm specializes in all intellectual property law-related fields. That is where I can identify an important moment that shaped my career and further developed my passion for IP law. I was appointed as the head of the litigation department on IP law in the office. This was important to me because I could identify my abilities, skills, and competence where I could effortlessly handle IP litigations for clients at the office at the time, spot legal issues and propose concrete solutions, identify difficulties raised with certain aspects of the law in IP litigations, and advise the clients on the approach to adopt regarding the specific issue in a case at hand. This was when I understood that intellectual property law was not only a passion for me but also a field in which I could express my abilities as a litigation practitioner and share my knowledge with clients from other jurisdictions. As a woman in the field of IP law, have you encountered any unique challenges or opportunities, and how have you navigated them? Yes, I did encounter some challenges in this field, as most OAPI agents are men who are not only very experienced but also more advanced in terms of age than I am. I realized that becoming an OAPI agent was very challenging as my direct competitors were men who had excelled in the field and who were much older than me. So, to navigate my way easily as an intellectual property agent in the OAPI region, I had to work extremely hard, quickly identify, focus, and develop my skills. Identify where I could effortlessly express myself in the field. When I identified these, I went in mostly for IP litigations, including counterfeiting, opposition, and claim of ownership, where I could effortlessly compete with the men in my jurisdiction and stand out. So, for over 15 years, I have been able to make my way slowly, progressively, and surely, and I am still doing this. What inspired you to pursue a career in intellectual property law, and how does your background contribute to your approach to innovation and protection of intellectual assets? My father was a writer who authored many pieces and worked very hard under my watchful eyes. Growing up, I saw him working and putting an impressive amount of effort into laying his knowledge down on paper, most of which was published out of the country via the Cambridge Editing Company. These books were sold in many jurisdictions, amongst those in the OAPI region. These very books he published, and which were sold in the OAPI region, were not protected, and as such, he faced a lot of legal issues with his work, such as plagiarism and counterfeiting, amongst others. Each time a case was going on, I would research how I could help him, and that is how I realized that there was a fundamental problem that I, myself, could fix with a lot of effort. Can you highlight a particularly memorable case or project you've worked on that showcases the intersection of creativity, innovation, and legal strategy in the IP domain? I remember working on the AfriPi project, which still exists today. I participated in the contest from start to finish, including all the 54 member states in Africa. Our office participated in the competition and ended up among the runners-up in the top 3. Even though we did not win the contest, it is and will always be a significant achievement, as it permitted us to realize how extensive our knowledge and experience in intellectual property law was. To do so on an international platform further solidified our confidence in our abilities regarding intellectual property law in the OAPI region. This project involved harmonizing IP law in Africa, giving it a harmonized viewpoint and harmonizing all the different aspects of intellectual property law. The idea was to harmonize intellectual property law applications in Africa, from Nigeria to the OHADA region and the EAPO jurisdictions, among others. Here, we went beyond our limits as per how we showcased our knowledge of intellectual property laws, exercised our know-how on intellectual property law, and expressed ourselves on a competitive platform on the OAPI jurisdiction and others. In your experience, what are some emerging trends or challenges in intellectual property law, particularly regarding the advancement of technology and its impact on innovation? Well, technological advancements are always good news in the field of innovation. Technology permits humans to do more in less time while maintaining a certain level of efficiency. Here, I am thinking mostly of artificial intelligence and its rapid evolution, which we can witness on a daily basis. The capacity to generate texts, designs, pictures, formulas, and resolve certain issues with a simple prompt typed into the right search engine is quite fascinating, and its furthering is definitely something to look forward to. Now, the problems that come with the use of technology, be it artificial intelligence or the internet as the interconnected network that we know can be cited, and amongst these are cybersecurity and cybercriminality. The challenges here in the OAPI region are that most of those affected by these issues do not have extensive knowledge of said concepts, such as the extent to which artificial intelligence stretches and how to manage it, and the risks involved, amongst others. When faced with a situation regarding these aspects of technology, they do not know the appropriate mechanisms to start their procedures and the adequate jurisdictions, courts, to handle these situations. For me, sensitization is the way to go in the OAPI region regarding the advancement of technology and its impact on innovation. The population in this region needs to be informed that technology is here to stay or, rather, to improve. Thus, there is a need to educate the population on emerging risks, such as the presence of scammers and hackers, amongst others. Also, the governments should ensure that adequate regulation is put in place, as one of the pervasive problems throughout the region is the lack of regulation in the field. I believe that if the governments in the OAPI legislate on this aspect so that intellectual property, technological advancements, and innovation work hand in glove, the environment will be much more conducive to technological advancements. How do you balance fostering innovation and protecting intellectual property rights, especially in industries with rapid technological advancements? Every company involved in technological development should hire an IP specialist to guide them on the importance of every innovation, its type, and the type of IP rights involved, with an emphasis on their exploitative rights. Also, in the OAPI region, about 20% of the elements in the innovation market are not aware of the importance of their products or services, their rights, or how to protect these rights. In this field, I believe that sensitization is also necessary regarding the importance of intellectual property, the link between IP and innovation, the intellectual property rights attached to innovations, and the necessity for any innovator to be effectively accompanied by an IP specialist, lawyer. As a patent or trademark attorney, what advice would you offer aspiring women considering a career in intellectual property law? I would like to encourage women to join the IP field as it is a field which requires the practitioner to be attentive and meticulous. Fortunately, and according to me, these are traits which women inherently have as daily life activities require these characteristics from them. As a black woman, I would encourage black women to join the field as I do not think there are enough black IP attorneys worldwide. So, I encourage every woman to go as high as they can in terms of academic training and expertise as far as intellectual property is concerned to be successful in this field of activity. Could you share insights on the importance of diversity and inclusion in intellectual property and how it contributes to fostering innovation and creativity? Regarding gender, women are taking up more space and fighting professional taboos as they work in fields such as technology, which was initially reserved primarily for men. Women are pushed into scientific fields and innovation. This, according to me, fosters the emancipation of women and the girl child and promotes innovation as other perspectives are involved as well as a larger number of people. As such, intellectual property benefits from these as the multiplication of innovators and innovations will directly influence the number of elements to be protected and the diversification of intellectual property categories to be protected. When discussing race, diversity stems from the fact that each person from a cultural system, a country, a continent, or ethnic descent has a different take on life in general and on innovation specifically. What looks pointless in one context can be the most useful in another, depending on each reality. Thus, this variety of experiences and perspectives is needed as the immediate effect will be to reshape how we view the world and help widen our points of view. In this regard, fostering diversity and inclusion in intellectual property will benefit innovation, breaking the barriers of conventionality, going further than what has already been done, modifying it, and taking it a step higher. Editor's final notes. In conclusion, the conversation with Barrister Bajuka Mildred Alugu sheds light on intellectual property law's dynamic and evolving landscape, particularly within the context of gender diversity, innovation, and technological advancements. Barrister Alugu's journey exemplifies resilience, determination, and a commitment to excellence in a traditionally male-dominated field. Her pivotal career moments, including heading the litigation department and participating in international projects like AFRIPI, highlight her expertise and dedication to advancing intellectual property rights. Furthermore, her personal experiences, such as witnessing her father's struggles with unprotected intellectual assets, underscore the importance of legal protection and innovation in fostering creativity. Barrister Alugu's insights on the challenges and opportunities faced by women and minorities in intellectual property law emphasize the need for inclusivity and representation. She advocates for increased awareness, education, and regulation to navigate the complexities of technological advancements and safeguard intellectual property rights effectively. Page 56. Article: Navigating the Intersection of Creativity and Legal Strategy, a conversation with Laura Castillo from Inventiva Espacio Legal. In this Candé with Laura Castillo from Inventiva Espacio Legal in the Dominican Republic, published in the Women's IP World Bite-Size segment of the Global IP Matrix magazine, Laura reflects on pivotal moments in her career, the challenges and opportunities for women in IP law, and the importance of diversity and inclusion. She shares insights from memorable projects, discusses emerging trends in IP law, and offers advice for aspiring women in the field. Through her experiences, she emphasizes the significance of balancing innovation and protection in today's rapidly evolving technological landscape. Hi, and welcome to the segment, Laura. Can you share with us a pivotal moment in your career in intellectual property law that shaped your approach or perspective? A defining moment in my career happened during a complex trademark prosecution endeavor for a corporation operating across the Caribbean region. Leading the strategic trademark registration process, I meticulously navigated the intricate regulatory frameworks of various jurisdictions while ensuring the comprehensive protection of my clients' brand assets. This experience profoundly shaped my approach to intellectual property law, highlighting the importance of meticulous research, strategic foresight, and proactive legal counsel in safeguarding clients' intellectual assets throughout their lifecycle. As a woman in the field of IP law, have you encountered any unique challenges or opportunities, and how have you navigated them? As a woman in the field of IP law, I have encountered both challenges and opportunities. One challenge has been breaking through traditional gender stereotypes in a male-dominated industry. However, this has also presented opportunities to bring a fresh perspective and innovative thinking to the table. I've navigated these challenges by focusing on my expertise, building strong professional networks, and advocating for inclusivity and diversity within the legal profession. What inspired you to pursue a career in intellectual property law, and how does your background contribute to your approach to innovation and protection of intellectual assets? My journey into intellectual property law was somewhat serendipitous. It all began when my sister invited me to collaborate on some projects in the field. What started as a casual invitation quickly blossomed into a genuine passion. I was drawn to the vibrant world of creativity and innovation that intellectual property law encompasses. I love that IP is not just about legalities, it's about preserving the colorful tapestry of ideas that drive progress and enrich our world. My multicultural background has equipped me to navigate diverse legal landscapes, enabling me to offer tailored counsel to clients on a global scale. Can you highlight a particularly memorable case or project you've worked on that showcases the intersection of creativity, innovation, and legal strategy in the IP domain? One particularly noteworthy endeavor I had the pleasure of being involved in was guiding innovative startups through their legal journey via our specialized service for entrepreneurs, Imprende, and my masterclass, Imprende en Orden, translated as Start in Order. Through these initiatives, I've had the opportunity to immerse myself in the vibrant world of promising ventures, learning about their revolutionary ideas and providing tailored legal guidance to safeguard their innovations. One project that stands out involved assisting a forward-thinking startup in securing trademark registrations, including the acquisition of 3D trademarks. These registrations granted them exclusive rights over the distinctive shapes of their creative and innovative products. It was a fascinating intersection of creativity, innovation, and legal strategy as we navigated the intricacies of intellectual property law to ensure our clients' ideas were protected and their businesses poised for success in the marketplace. In your experience, what are some emerging trends or challenges in intellectual property law, particularly regarding the advancement of technology and its impact on innovation? A notable trend in IP law is the growing complexity of safeguarding intellectual property rights in today's digital landscape. With rapid technological progress, challenges like digital piracy, data privacy issues, and the emergence of AI-generated content have come to the forefront. Addressing these challenges means keeping up with evolving legal structures and using technology to develop innovative approaches to IP enforcement. How do you approach the balance between fostering innovation and protecting intellectual property rights, especially in industries where rapid technological advancements are prevalent? Balancing innovation with IP rights is crucial, especially in fast-paced industries. However, securing registrations can be challenging due to lengthy processes, which may cause us to miss trends. This is true in many countries, particularly in most Caribbean islands, where the registration process is lengthy. This can pose a significant hurdle, especially considering that by the time we secure the registration, the trend or technology we seek to protect may have evolved or even become obsolete. In the case of the Dominican Republic, we've streamlined registrations to 3 to 4 months for trademarks and 6 months for industrial designs. To strike a balance, I advocate for a legal framework that fosters creativity while ensuring protection. I suggest that companies and individuals enter into licensing agreements to collaborate on sharing their intellectual property. By doing so, they not only facilitate innovation by pooling their resources and expertise but also promote knowledge sharing, which can lead to further advancements in their respective fields. In essence, these collaborative efforts contribute to the overall progress and development within the industry. As a patent or trademark attorney, what advice would you offer aspiring women considering a career in intellectual property law? I feel so blessed I had the chance to focus my legal career on intellectual property. If you aspire to enter this field, I encourage you to do so because it is the most dynamic and rewarding domain to specialize in. I would give these 3 tips that are my go-to principles every day. Embrace your unique identity and recognize the invaluable perspective and contributions you bring to the field. Be fearless in pursuing your passion. Seek out mentors for guidance, and never underestimate the power of networking and making connections along your journey. Could you share insights on the importance of diversity and inclusion in intellectual property and how it contributes to fostering innovation and creativity? By embracing diversity, we create an environment where innovation flourishes, as individuals from different backgrounds offer unique insights and approaches to problem solving. Inclusive workplaces attract top talent from diverse backgrounds and foster a culture of collaboration and creativity, leading to the development of more robust and innovative solutions. Additionally, diverse teams are better equipped to understand and serve a wide range of clients and communities, ultimately driving positive outcomes for all stakeholders. Therefore, promoting diversity and inclusion within the intellectual property field is not only a matter of social responsibility but also a strategic imperative for driving innovation and success.
Page 58. Advertisement. Join us at INTA TAMP 2024. Trademark Administrators and Practitioners Meeting. September 22nd to 24th, 2024. Philadelphia, Pennsylvania, USA. International Trademark Association. Learn more at www.inta.org/inta-events.
Page 59. Conference Corner. 2024 Voices of the Associations. Carolina Belmar, Chief at INTA, LATAM and the Caribbean Office. IP, Data and Cybersecurity Lawyer, Chile, Anthony Douglas. Legal Director, IP, Data Protection, Marketing and Digital Strategy at Specsavers and Chair of the Marquess Council, Karina Gomez. ECTA First Vice President responsible for the ECTA Academic Program. This segment is dedicated to our esteemed IP event organizations and associations with whom we have established media partnerships across the globe. We are privileged to provide them with a platform to keep you, our valued audience, well informed about upcoming events and the latest trends in IP conferences throughout the year. By staying connected with us, you can ensure that you never miss out on any of these significant international events and enriching seminars. The Global IP Matrix. Official Conference Media Partners. For 2024 Conference Media Partnerships. Contact info at gipmatrix.com. Page 60. Article. Expanding in Latin America and the Caribbean, an update from INTA. Written by Carolina Belmar, Chief at INTA, LATAM and the Caribbean Office. IP, Data and Cybersecurity Lawyer, Chile. Author bio, Carolina Belmar has over 20 years of experience in domestic and international engagements. In 2022, she joined the International Trademark Association, INTA, as Chief Representative Officer for Latin America and the Caribbean. She previously directed the Trademark Division of the Chilean Intellectual Property Office from 2009 to 2018. Before that, she led the Intellectual Property Department at the Chilean Ministry of Foreign Affairs. She co-founded the startup AI Trademark in 2016. Additionally, she serves as an external arbitrator for the Chilean Journal of Law and Technology and has contributed to various academic and legislative initiatives in the field of intellectual property. The International Trademark Association, INTA, has been gradually expanding both its substantive and geographic scope in recent years. Intellectual property, IP, rights are increasingly complementary, and brand professionals' portfolios now include a variety of IP rights. This led INTA to expand its remit to include complementary rights, including designs and copyrights, and most recently, trade secrets. In terms of its geographic expansion, the association must represent and serve its global membership of more than 6,400 organizations in 181 countries, representing nearly 33,500 brand professionals from major corporations, small and medium-sized enterprises, law firms, and non-profits, as well as government agencies and academia. In addition to its headquarters in New York City, INTA has 5 representative offices in Beijing, Brussels, Santiago, Singapore, and the Washington, D.C., metro area, and representatives in Amman, Nairobi, and New Delhi. Established in 2017, the Santiago office represents INTA throughout Latin America and the Caribbean. It leads the association's advocacy and serves its members in 46 jurisdictions comprising 33 countries and 13 territories, each with its own local trademark registries. INTA members in the region include more than 600 organizations and nearly 3,000 individuals. On their behalf, the office monitors developments and trends in trademarks and other IP rights throughout this incredibly diverse region with many local differences, the distinctions among which determine how the association approaches its work and guides its focus and efforts. Fostering meaningful relationships with key IP stakeholders. Working closely with INTA's Latin America Global Advisory Council and numerous committees with regional subcommittees focused on the region, the Santiago office engages a variety of local stakeholders to advance INTA's strategic goals in the region. Facilitating dialogue with and between policymakers, law enforcement authorities, academics and, of course, our members, the office is constantly exploring new ways to bring the work of the association to bear while serving the regionally specific needs of our members throughout the region. This includes providing tailored events that address the specific needs of brand owners and professionals today. Key issues in focus right now include counterfeiting, non-traditional marks, developing legislation and regulation, and trademark office practices. The office prioritizes strengthening ties with key players in the IP ecosystem, with efforts primarily focused on IP offices and enforcement agencies. During the course of last year, INTA made significant strides in these efforts to foster collaboration. The association hosted 11 training sessions for law enforcement officials in the region, 9 workshops for IP offices, and a specialized workshop for judges in Buenos Aires, Argentina, where INTA representatives had the opportunity to meet with more than 40 judges. A recent and notable achievement was the successful engagement with IP offices of the English-speaking Caribbean, which resulted in a technical dialogue among officials from the island nations, who exchanged best practices related to formal requirements in trademark applications. This was followed up with a second dialogue last month with the same IP offices, designed to enhance the collective understanding of the issues and to address existing challenges in a more streamlined manner. As 2024 progresses, INTA is preparing to launch a dynamic multimedia educational program for the Brazilian judiciary. Close collaboration with local IP associations ensures the program will be finely tuned to meet the audience's needs. The success of these various initiatives stems from a tailored approach that speaks to the unique needs and interests of our members and key stakeholders throughout the region. Reaching key non-IP stakeholders. Interestingly, the fundamental question of why IP rights deserve protection occasionally resurfaces in Latin America and the Caribbean. The absence of a long-term public policy for economic growth that includes industrial property rights as an essential economic driver may contribute to this lack of understanding. However, positive changes are evident, and INTA's efforts are focused on elevating the topic among key stakeholders outside the IP circles and raising awareness among the public at large. INTA is working earnestly to capture the media's attention and generate interest in IP. These are opportunities to educate business leaders, policymakers, and the public at large about the positive role of IP in society and to promote INTA's work. In 2023 alone, media outlets in Argentina, Brazil, Chile, and Mexico published more than 40 articles in which INTA conveyed its position on pertinent issues. This year, the representative office seeks to expand its reach and engagement with local media outlets in additional jurisdictions. A useful tool in this endeavor to reach and engage our non-IP stakeholders is the economic impact study conducted by INTA in 2020. Titled Trademarks in Latin America, Economic Impact in 10 Latin America and Caribbean Countries, the report highlights the positive contribution of brands to the economic growth and welfare in the region. INTA conducted a similar study looking at the association of Southeast Asian nations. The INTA leadership regularly references these studies when engaging with policymakers, as well as similar studies produced by the European Union Intellectual Property Office, the World Intellectual Property Organization, and the United States Patent and Trademark Office. These global studies offer both benchmarking opportunities and the type of data that can also be used by legislators and governments to bolster a case for investing in IP infrastructure. In the academic space, an exciting project spearheaded by the Latin American and Caribbean Representative Office is the Latin American Moot Court Competition on Intellectual Property Laws. Developed in collaboration with the Andean Court of Justice, the competition encourages the study of IP among future lawyers. Last year's competition attracted 36 teams from 11 countries. This year, with the support of a third regional partner, the winning team will receive US $3,000 in addition to the usual prizes. Law schools and students interested in participating can find more information on the INTA website. Advocating for brand owners and consumers. One of INTA's policy priorities in the region right now is brand restrictions. Governments in some Latin American countries have enacted laws requiring brands to add labels to their product packaging marked with high-in or other brand restrictions on the food labels of food products linked to high-calorie intake. Such restrictions are becoming increasingly popular among governments in the region and globally to address public health and social issues. One of the key drivers of brand restrictions is the perception that health is directly related to trademarks and branding. INTA's 2021 report, Brand Restrictions Study, A View from Gen Zers and Millennials, examines how the world's largest generations view brand restrictions legislation and regulations and how their purchasing behavior could be affected by these limitations or bans on packaging design elements. It has enabled the association to maintain an ongoing dialogue that urges policymakers to explore alternatives to brand restrictions and to maintain a balance between public health policies and trademark rights based on compelling and credible data. INTA has been advocating globally about the negative impact of brand restrictions. Its position on the matter is established through a board resolution, from which all policy and education initiatives stem. In 2023, INTA actively participated in public consultations aimed at updating laws, regulations, or IP offices guidelines in Brazil, Chile, and Colombia. Earlier this year, INTA issued comments to the Bahamas government's public consultation for the development of new IP laws. The association also recently voiced concern at the European Commission annual meeting about counterfeiting issues in Mexico under the trade agreement between the respective governments and is working on a strategy to improve the situation for brand owners and consumers in Mexico. All in all, INTA and its Santiago representative office's efforts aim to provide holistic, substantive support across the region, serve its diverse membership, and elevate and promote IP's role in the lives and economies of the people throughout Latin America and the Caribbean. Page 62. Article. Shine Bright in Antwerp at the ECTA 42nd Annual Conference. Written by Carina Gomez, ECTA First Vice President and Partner at Wigan LLP, Belgium. The countdown has begun. Antwerp will sparkle from 19 to the 22nd of June 2024, as the ECTA 42nd Annual Conference, with the theme Many Facets of IP, takes center stage. Known as the City of Diamonds, Antwerp offers a radiant setting for exploring the diverse realm of intellectual property. Registration is open, so take advantage of the chance to secure your spot for another rewarding ECTA experience surrounded by hundreds of IP colleagues and friends from around the world. The agenda is rich, covering a wide range of interests. Beyond exploring the latest IP trends and case law, this year's conference aligns with the 2024 WIPO theme, IP and the Sustainable Development Goals, SDGs, placing a special focus on sustainability, a pivotal factor for a brighter future. Significant emphasis is also reserved for diversity and inclusion, which are fundamental to a forward-looking IP landscape. Let me give you a glimpse behind the curtain. Wednesday, the 19th of June, committee meetings kickstart and welcome reception. Committees will meet again to delve into impactful IP projects and case law updates, and the Supervisory Board will debate more strategic aspects of the association. Delegates will also learn more about IP mediation and ADR in a dedicated workshop before a welcome reception at the enchanting Horta Grand Café. Thursday, the 20th of June, educational immersion and Belgian tasting. Attendees will dive into the latest IP news, discussing sustainability in trademarks, the role of AI in shaping the future, and the impact of IP in the food industry. Committee leaders will be available to meet with interested colleagues at the committee corner and, at ECTA at a glance, we will toast with first-timers and share insights on how to get the best out of our association. The day concludes with a gourmet taste of Belgian delicacies in the Convention Centre Gardens, connected to the Antwerp Zoo, an award-winning science and research centre, exceptionally open for an evening walk. It is worth noting that all profits from the Convention Centre will be donated to the ZOO Foundation. Thus, the conference will directly contribute to nature conservation, zoological research, and animal welfare. Friday, the 21st of June, Learning Boost and Gala Dinner. Delegates will continue their IP exploration, delving into topics such as copycats, diversity and inclusion, animal trademarks, traditional knowledge, and the most recent EU case law updates. ECTA award winners will be celebrated, and the conference will conclude with a dazzling gala dinner at Handelsbeurs, the world's first purpose-built commodity exchange building. Saturday, the 22nd of June, excursions, upon reservation. ECTA friends can sign up for a half-day tour exploring the city of Antwerp or a full-day adventure uncovering the secrets of diamonds and Belgian chocolate. Last but not least, Antwerp's central location ensures easy access for many European colleagues. It is seamlessly connected by high-speed train to major cities such as Paris, Amsterdam, London, and Cologne, and is just a swift 30-minute train trip from Brussels International Airport. Moreover, the Flanders Meeting and Convention Centre Antwerp, FMCCA, where the event occurs, is conveniently located in front of the famous Antwerp Central Station. It promises to be a not-to-be-missed annual conference where you will forge new connections in a friendly atmosphere while staying abreast of the latest IP developments. If you are not yet an ECTA member, join the association and attend the conference at the discounted member rate. I look forward to seeing you all in Antwerp.
Page 63. Advertisement. ECTA Antwerp. 19 to June 22, 2024. Many facets of IP. Get ready to shine bright. Indiana Antwerp, 42nd Annual Conference. Come and join us in Antwerp to experience firsthand the many facets of the next ECTA Annual Conference. Contact us.
vu.etsta.org.
ECTA Secretariat.
Plus 32 2513 5285.
Page 64. Advertisement.
Marque.
The 38th Annual Conference. The many traits of the trademark experts. Tuesday 24th to Friday September 27th, 2024.
Radisson Blu Waterfront Hotel, Stockholm.
v.marius.org. Twitter X Marcus = IP.
Page 65. Article. A Busy Year for Marques. Written by Anthony Douglas, Legal Director, IP, Data Protection, Marketing and Digital Strategy at Specsavers and Chair of the Marques Council. The 37th Marques Annual Conference, held in Berlin in September 2023, was the best attended ever, with more than 950 registered delegates. It followed the 2022 Annual Conference in Madrid, which was also a great success. The annual conference epitomizes all the strengths of Marques, which has been the leading voice for trademark owners in Europe for nearly 4 decades. The event provides unrivaled opportunities to learn about legal and business trends, innovative case studies, and emerging challenges, and to network with colleagues and clients from more than 80 countries. However, the annual conference is just one part of what Marques does for its members and the IP community at large. The association's achievements are built on the back of intense volunteer-led work by its 18 teams, which cover everything from trademark, design, GI, and copyright law to regulation, unfair competition, anti-counterfeiting, dispute resolution, and emerging issues, and targeted task forces that address key issues such as anti-fraud and sustainability. The work of the Marques teams in keeping members informed is particularly important given the number of significant developments in IP, such as the planned International Design Law Treaty, the new Directive and Regulation on Designs in the European Union, the new EU regulation on non-agricultural geographical indications, and ICNN's new registration data request service. Marques engages with IP authorities and political bodies and institutions, notably national and regional IP offices and IP organizations such as EU IPO and WIPO, the European Commission, and ECON, to promote the interests and address concerns of brand owners. In recent years, we have been able to influence developments, including the EU trademark reform, the EU design law reform, and the development and modernization of the Madrid system for the international registration of trademarks and the Hague system for the international registration of designs, leading to tangible benefits for IP owners. Another area of focus for Marques is representing brand owners' interests before relevant courts, including filing amicus briefs and/or making submissions where appropriate and permitted. The hard work and creativity of our volunteers, coordinated by the Marques management and the internal and external relations officers, help deliver a wide range of useful resources for members. These include online fact sheets, Candé guides, and interactive trackers, regular updates on legislative developments and case law, and a regular program of online and in-person events. Information about all of these activities and resources can be found on the Marques website. Each year, in addition to the annual conference, Marques hosts a spring meeting where council and team members discuss current and pending projects and areas of focus for the association. Other activities include the Meet the Judges and the Luxury Brands Symposium events and training webinars on daily practice topics that are indispensable for IP practitioners both in-house and in private practice. In 2024, we will hold several of these events, including the 5th Luxury Brands Symposium, which will take place in Vienna on the 7th and the 8th of November. The Meet the Judges events, at which leading judges discuss case law trends with practitioners, have been very well received. Recently, we have held these in London, UK, and Munich, Germany, and we expect to announce further meetings later this year. Since the pandemic, it has become clear that many practitioners, especially younger and more junior members of the profession, value online education and networking. Marques, therefore, has a busy program of webinars covering a wide range of emerging topics such as social media, advertising slogans, AI, blockchain, and IP. The popular Talking Marques podcasts also provide insights into current and emerging issues, with new episodes uploaded every couple of months. Among our most successful activities are the online coexistence agreement workshops, which provide a unique learning opportunity for junior practitioners based on a realistic case study. Such is the popularity of these workshops that we are exploring how to roll out the format to cover other topics. Watch this space. At its heart, Marques is a brand owner-led association, and we deeply value the involvement of our corporate members. They help to shape the priorities of the association and inspire its leadership. Our chair and vice chairs are always from corporate members. Over the last 2 years, a dedicated Marques corporate focus group has organized a range of activities specifically for the corporate members. These activities include the corporate breakfast at the annual conference and quarterly webinars aimed at facilitating exchanges on practical issues. Corporate members say they welcome the opportunity to learn from each other and discuss the day-to-day challenges they face in these sessions. We have also launched a dedicated page on the website for corporate members, which includes summaries from events, valuable resources, and contact details. To learn more about Marques, please visit marques.org or consider registering for one of our events. Registration for the 38th Marques Annual Conference will open in May 2024, and we would love to see you in Stockholm, where this year's event will take place from 24 to the 27th of September. The theme of the annual conference will be the many traits of trademark experts, and topics due to be covered include public relations and IP disputes, consumer awareness and brands, effective online enforcement, visual disclaimers in designs, and registration versus the use of trademarks. Save the dates now and book your place when registration opens.
Page 66. Advertisement. United Trademark and Patent Service. Intellectual Property Attorneys. Your reliable partners for intellectual property matters in Pakistan, South Asia, Arabian Gulf, Middle East and Africa. Trademark, patent, design, copyright, domain name registration, litigation and enforcement law. Pakistan Office. 85, The Mall Road, Lahore 54000 Pakistan. Adjacent Radho Kronos/Hang 10 Mall Plaza Building. Telephone. +92 42 362 85588 to 90, +92 42 362 85581 to 84. Fax. +92 42 362 85585, 362 85586, 362 85587. Email, unitedtrademark@unitedtm.com. Websites www.utmps.com and www.unitedip.com. Page 67. Advertisement. AIPPI 2024 AIPPI World Congress. Hangzhou. 19th to October 22, 2024. Super Early Bird registration opens May 21, 2024. Location, Hangzhou International EXPO Center, HIEC. www.aippi.org.
Page 68. Article. Exploring the Frontiers of Intellectual Property, a sneak peek into the 2024 AIPPI World Congress in Hangzhou. The vibrant city of Hangzhou is set to host the 2024 AIPPI World Congress, promising an enriching blend of intellectual property insights and cultural experiences. From 19 to the 22nd of October, IP professionals from around the globe will converge to delve into the latest trends and challenges shaping the world of IP. The excitement kicks off with the opening ceremony, followed by a warm welcoming reception, setting the stage for 4 days of innovation and collaboration. On Sunday, we dive into the heart of copyright issues. The plenary session explores the defense of parody, while Pharma Day will examine topics like the intersection of drug discovery and AI, trademark use in pharmaceuticals, patenting microbiomes, and digital therapeutics, Off My Body. Meanwhile, one of 4 panel sessions delves into the evolving landscape of IP examination and protection in China. The agenda continues with a focus on patents, including discussions on the harmonization of disclosure requirements and consequences of non-compliance during a plenary session. Panel sessions tackle diverse issues, such as referential trademark use and the intricacies of trademark exhaustion. Meanwhile, the AIPPI Café sessions offer roundtable discussions on topics like green fashion and keyword advertising. The day also features the Young AIPPI Forum, providing a platform for emerging voices in the field. As the Congress enters its final day, speakers explore patent term extensions and the IP landscape across China, Japan, and Korea. AIPPI cafes offer insights into FRAND licensing, trademark surveys, and open licensing of patents. The General Assembly and Executive Committee too get the honor of final sessions before diving into a culinary experience during the memorable closing dinner. At the heart of each AIPPI Congress lie the plenary sessions and executive committee meetings, where pivotal AIPPI resolutions take shape. These sessions serve as forums for passionate debates among delegates from diverse backgrounds and expertise. Issues ranging from copyright to patents, trademarks, general and design are analyzed and refined to form resolutions that reflect the collective wisdom and consensus of the global IP community. Executive Committee 2 marks the culmination, where these resolutions are finalized and ultimately voted upon, shaping the future trajectory of intellectual property law and practice worldwide. The 2024 AIPPI World Congress in Hangzhou promises to be a journey of discovery, collaboration, and cultural exchange. With a diverse array of sessions covering sustainability, UPC, patents, AI, designs, and more, participants will gain invaluable insights and forge meaningful connections in the dynamic world of intellectual property. Join us for an unforgettable experience at the forefront of innovation and creativity.
Page 69. Advertisements. Advertisement 1. WebTMS. IP Portfolio Management Software. WebTMS stands as a reliable partner for IP professionals. We deliver an outstanding and innovative software backed by exceptional support. Our dedicated team are equipped with trademark paralegal knowledge. Get in touch and we'll show you how WebTMS combines cutting-edge technology with exceptional expertise to make you more effective in your role. Sale at webtms.com. INTA booth number 834. Advertisement 2. World Litigation Forum. WLF 2024 Europe. Barcelona, Spain. 25th and September 26, 2024. Discover our first 3 speakers. Philip Kurek, partner at Signature Litigation, United Kingdom. Alina Sukmanova, partner at Sayenko Karenko Law Firm, Ukraine. Carlos Eritreadu, equity partner at Quatercasas, Spain. Register now.
Page 70. Advertisement. The Caribbean IP Annual 2025. Promoting IP excellence in the Caribbean. Making its debut in 2025. Northons Media PR and Marketing Ltd. is thrilled to announce the highly anticipated launch of our newest publication, the Caribbean IP Annual. Our goal with this publication is to continue promoting and highlighting the excellence in intellectual property within the Caribbean region. By providing valuable insights into the constantly evolving IP landscape of the 13 sovereign island nations, we hope to contribute to the growth and development of this vibrant industry. Stay connected with us for all the latest updates and a comprehensive understanding of the intellectual property sector in this dynamic region. If you happen to be an IP law firm, practitioner, or business owner, we would be delighted to receive your inquiry. Our new platform presents a unique opportunity for you to showcase your knowledge and engage with a captivated international audience seeking referrals, business collaborations, and valuable insights into IP matters within your specific jurisdiction. www.caribbeanipannual.com. Email icipannual@northonsprmarketing.com. Call +44 02038130457.
Inside back cover advertisement. Sing and Sing. India's finest IP advisory on copyright, trademark, prosecution, etc. Sudeep Chatterjee. Senior Partner. Member INTA Enforcement Committee. Asian Patent Attorneys Association. Counselor and Secretary APA, Indian Group. Sing and Sing Law Firm LLP. C130, Defense Colony, New Delhi 110024, India. Handheld, +929820676281. Direct, +911149826091. Email, sudeep@singandsing.com.
Outside back cover advertisement. Pat World. Paying more than you need for reliable patent intelligence? Pat World, the trusted choice for IP research services. Pat World is a leading provider of patent, design, and trademark research services for professionals worldwide. With over 18 years of experience and a team of highly trained and dynamic in-house researchers, we offer comprehensive and accurate results that you can trust. Our services. Whether you need patentability/novelty searches, freedom to operate, FTO/infringement analysis, invalidity/patent busting searches, or state-of-the-art and competitive intelligence research, we have got you covered. www.patworld.com. Email, mail@patworld.com. Phone, +44 01633816610.
You have been listening to issue 19 of the Global IP Matrix magazine. If you would like to be part of the industry's #1 IP publication to share your knowledge with the global IP community, then please reach out to us at telephone +44 0203 813 0457 or email us at info@gipmatrix.com. Visit our website www.gipmatrix.com. Thank you.